I have your lordship leave to mention a review matter, my lord. Review of civil matter, my lord. The judgment was delivered by Justice Tandon, my lord, sitting with your lordship, my lord. Your lord. I have filed.
May I permit to mention one?
I serve notice upon the
We have served. Next week.
Okay.
Next week, Monday.
May I permit to mention one Group 9 hearing matter, my lord? Well, the matter is ready for hearing. My lord, as per the order dated 16 May 2024, my lord, there is a status quo due to which the state of Mizoram is not being able to construct the land for benefit of public. And public money is also involved, my lord. For public benefit, the land is not being able to be constructed.
Hearing matter.
Hearing matter, my lord. Group 9, it's ready for hearing, my lord.
Hearing we have taken up on Thursday. There was nobody there on that day.
But public money is also involved, my lord.
It will be included in the next list. You give it. It will be included. It's not on the list.
Not in the list, my lord.
Yes, inclusion next monthly list.
Next one.
Monthly list. Give.
My lord, I am paying for inclusion in the list, man.
Give inclusion. You can give.
My lord, this is also inclusion.
Give the inclusion.
Item number 1.
Item number 1, Lordship, Mr. Othono Visas is appearing for the petitioner. I am just praying short password, Lordship.
No, sir. First case in.
Lordship,
I am appearing on behalf of the Union of India.
just 2-minute password, Lordship. He is on his legs. Just 2-minute legs. 2-minute password, Lordship. He is on his. So I don't have the brief, Lordship. Just 2-minute, Lordship. 2 minutes password, Lordship.
Judgment and order passed by the. Yes. The second round of Blattel. My lord, in this matter, my lord, I am appearing on behalf of the petitioner. My lord, the petitioner's claim for family pension of her deceased husband who was an ex-AGM in BSNL. My lord, pursuant to an order passed by the learned tribunal in an earlier proceeding, the department considered the applicant's case and rejected. And against that, we moved before the learned tribunal and the impugned order has been passed. My lord, in course of hearing before the authority concerned, let's say notice was issued on, notice is at page 78.
Forget about notice. How do you substantiate your claim? Tell us.
My lord, in support of my claim that I am the legally married wife of the deceased employee, I produced some documents which are at page 79.
How the tribunal can look into this aspect?
Let's say
Tribunal does not have jurisdiction to look into this aspect.
let's say the department has department has not appreciated this document. In respect of the marriage, digital marriage certificate, a wrong finding is there.
Kindly
My lord,
refer to
order.
the, paragraph 9 of the
Please.
My lord, order passed by the learned by the respondent authorities is at page 84. My lord, kindly have a look. There are three reasons they have assigned. Number one, the service book of deceased Ishad Ali, including the last family declaration on 10/7/2013, made by him, do not have any mention of Srimati Laila Begum as his legal wife. Accordingly, after superannuation of deceased Ishad Ali from service on 31st August 2023, the PPO book issued by CCA DOT cell contains the name of Srimati Anwara Begum as his legal wife. Number two, the marriage certificate dated 9/5/1998 as submitted by Srimati Laila Begum do not contain the signature of issuing authority. My lord, this document is a digital certified copy. My lord will find it at page 20. Oh, page 40.
second marriage করতে গেলে permission লাগে। মুসলিম হোক আর হিন্দুই হোক।
40 is the digital certified copy in respect of the registration of marriage before the Muslim marriage register and Qazi. And page 21 is the original copy in vernacular, and page 41 is the original copy of marriage registration, and page 42 is the translated copy, my lord.
21. There is nothing.
It is 41, my lord. 21 was before the learned tribunal. Page 40, 41 and 42.
একটা জায়গায় তো একটা জায়গায়
Now, my lord, page 43.
You have any children also?
My lord.
You have any children
Yes, my lord.
from the wedlock?
Page 43.
From the
page 40
wedlock, you have
Yes,
children?
yes. One male child is there. He has completed already BTech. Page 43 is the birth certificate. 44 is the ration card of the child.
What is the date of demise of your husband?
Death certificate.
But in the first round of litigation,
Can
The-
you please wait?
Page 54 and 55. Death certificate of the deceased. Page 54 was issued by the hospital and page 55 was issued by the corporation.
claim of
10/3/15.
My lord.
10/3/2015.
My lord.
Where is the way order passed in the first way?
Page 64 to 69. An operative part is at page 69. The earlier page at page 68, I relied upon a judgment of the Honorable Supreme Court. That was also quoted in GL Bhatia's case.
Which one?
But page 79 is the list of documents which I
Marriage. 9598.
কালকে মেয়ের নামটা থাকবে লিস্ট। Now,
How?
before the
You will have to prove these documents.
See, prima facie, my lord will find from page 79 that the documents I have relied upon in support of my legal marriage. Lordship, that has been established. Lordship, the department has intentionally refused, but tribunal is silent. Tribunal has, while rejecting my claim, tribunal has relied upon only Rule 50, Sub-Rule 6 of the pension rule, CCS Pension Rule 2021, whereas my case covers under the CCS Pension Rule 1972. My lord, as per Rule 54(7), my lord, there is scope to grant
It is covered by which CCS?
CCS Pension Rule 1972, whereas the learned tribunal has relied on Rule 50, Sub-Rule 6 of CCS Pension Rule 1921, which is not applicable in my case. Rule 54(7) says, of the 1972 rule says, 7A1, where the family pension is payable to more widow than one, the family pension shall be paid to the widows in equal shares. 2. On the death of a widow, her share of the family pension shall payable to her eligible child, provided that if the widow is not survived by any child, her share of the family pension shall not lapse but shall be payable to the other widows in equal shares, or if there is only one such other widow, in full to her. And now
You'll have to establish your claim, what can be done.
my lord,
Even
now
if both of you are entitled, even if the
both
72 rules,
of us were entitled. Now the
how many times you will say the same thing?
my lord, the
What we are saying is,
other
even
widow
if
has
that,
expired.
even if that applies, unless you prove that you are married, how you can get it?
Sir, my registration, marriage registration certificate is there. None has denied this.
We don't know.
Even the respondents have been have not denied.
We don't know.
No, it is
That's
admissible.
not the forum to decide. That is the problem. Can we decide this? We cannot.
And my lord,
Neither the tribunal can decide it. Neither the authority can decide.
fact finding is authority is the department also.
Huh?
Fact finding authority is the department.
So the department will declare a marriage to be valid and invalid.
No, no,
Is that your submission?
that's not my submission, but they
Then
could have verified this.
what can be done? Nothing can
And
be done.
so far, this rule of 2021 is concerned, on which ground the learned tribunal has
See,
rejected
it
my
would have been a different thing if your name had been included in the list. He has given a nomination just before his retirement. Yes.
my lord.
Just before his retirement. And you
Deeply
said you
obliged
were
to
married in 98.
my lord.
Since 98 till he retired in 2013, he has never stated your name
Now, your
anywhere.
lordship kindly consider some other things.
Yes.
Before the tribunal, there were two sets of reply. One set by respondent number 1 and 3. Second set is by respondent number 2, 4, and 5. Now, kindly come to the reply documents which they have relied in support of their reply. Kindly come to page 94.
Yes, we have seen 94. That is
My
why
lord,
we are
this is
saying.
my lord, kindly.
What is the date? See, July
July
2013.
10, 2013.
Just before retirement. He has retired in August.
This was filed by respondent number 1 and 3.
Yes.
Now, your lordship kindly come to, there are 4 names my lord will find.
Yes.
Now, kindly come to page 125. That was a form 3 under rule 5412. This is also form 3 rule 5412.
Which page?
Page 125. This is also dated 10/7/2013. My lord, kindly have a look. Lordship, there are differences between these two documents, which are coming from the respondents. At page 94, my lord will find a name of 4 persons, whereas in 125 there are 5 persons. On attesting authority, signature same.
What is your name?
My name is Laila Begum.
Where is your name?
My name is not there. Now, as a wife, one Anwara Begum is named.
Sorry.
And now, your lordship, kindly come to some other documents at page 141 onwards, which are filed by the alleged first wife before in the earlier proceeding. Lordship, here that lady was named Nur Banu Begum. They made a declaration before the sub-register.
That's why we are saying who will go into this question? The tribunal.
No, lordship, kindly.
Who will go into this question? You tell us. Which is the forum which will go into this question? Tribunal? Administrative tribunal? Please tell us. Or we will examine it in writ jurisdiction.
Department could have scrutinized the document, my lord.
That's why we are saying the tribunal can do it.
Department could have checked it.
Department will declare whether this document is valid or invalid. This registration of marriage is valid, invalid. Whether it is issued by a competent authority, whether it is valid.
Problem is that the first wife has passed away.
That is a problem
Against
for
whom
you,
I
we
shall file
understand. But the problem, for every problem, there has to be a solution. So you have to
If
pursue
I
your
file suit
solution.
for declaration against the alleged first wife,
Yes,
but she is dead now.
obviously. So we don't know how, we are not here to advise you what kind of suit you will file. You know better.
And that no, but apart from that, I relied on 3 judgments before the learned tribunal also.
What judgment?
This is
Show us one judgment that tribunal can decide this issue. Show us one judgment that when a person is not a nominee, the tribunal can decide that she is a wife.
And
Show
this
us
is
one judgment.
1999 Supreme Court SCC Volume 5 237.
On this point, the tribunal will decide that she is a wife.
It has been decided that mere non-nomination shall not
Let us see.
disentitle him. 99 SCC Volume 5 237. 237. Now, paragraph 5 is the relevant. It's very short judgment.
Nominee is not available. Nominee is available.
No nominee নেই। In this case also there was no nomination in the service book.
Yeah, there is no second husband claiming here.
No, but
Please, now show us which other judgment.
this was here in this case the petitioner's name was
That we have seen, sir. There is no other person claiming. That's why we are saying, who will resolve this issue? That is the problem. We
And
can
this-
see your problem,
this
but
is
there
regarding
has to
another
be
that
a,
if personal law permits second marriage.
who is going to examine this? Administrative tribunal. You are making all these submissions before a forum which lacks the jurisdiction to go into this issue.
Well, but none has said that this document is not a valid document. It is admitted document, my lord.
All right. Admitted. Where is the admission? Show us.
My lord, none has disputed this.
Please show us the admission, sir. Admitted. You say admitted so easily.
So far it
Show us
has
the
been
admission.
disputed, my lord.
What no one has disputed. You have to prove these documents. Where's the question of disputing? You are claiming a status of a wife based on 3 documents. In the 2 nominations filed by the deceased within a month of his retirement, he has not named you. Chosen not to name you as a wife.
But the documents which was
all.
found, the name of the wife has been mentioned as Anwara Begum. But who is Anwara Begum? That person who claimed to be Anwara Begum, his name was
That's
not
all.
there.
Anything else?
No, the 2 other judgments I am relying.
Show us, give us
What are the-
whatever judgment you want to show us.
This is laws, Madhya Pradesh High Court 2016,
You have given us 199.4.
99-5. SCC 99, volume 5.
Which judgment he is giving us? Where is the citation of this judgment?
That in the, it is, I have printed it from the laws. In the second page, parallel citations are there. In the, কোনটা? না ওইটা কই? আরে ভাটিয়াটা।
99.5 SCC 237.
My lord.
Then which other judgment?
And this is laws, Madhya Pradesh High Court 2016, volume 3, page 69. It is also reported in EIC 2016. Relevant paragraphs are paragraph 11, 15, and 17. Madhya Pradesh. Well, here the concerned rule was also perimeteria with that of Rule 54(7) of the CCS Pension Rule 1972.
Yes, the nomination contained his name. Yes. Any other judgment?
And another one is the Division Bench of Guwahati High Court. Laws Guwahati 2017, 12, page 98, paragraph 3 and 4. Paragraph 2 is also may be considered. It's a 2 pages judgment. No, mostly.
The legal heirs, other legal heirs, were they party before the tribunal?
Yes, I have also made them party here also.
Have they filed any
No,
reply
They
before
have
the
not
tribunal?
contested. They have not contested.
They have not filed any reply.
They did not appear.
Where have you said that? In your writ petition, show us that government.
Paragraph 28 at page 12.
Where is the reply filed in the earlier way?
That is not here with
Please
now.
show us.
Some documents are I have annexed.
Please show us.
The reply is not
You
with me.
come with it if you want. The learned advocate.
We start, my lord.
What?
They file supplementary affidavit, my lord.
Yes, we have said he will serve.
How we fixed to check?
I require to file a supplementary affidavit in
Obvious.
annexing the-
Enclose that because that is the only pleading having the stand of the first, the wife who is nominee. So let us see what she has said.
But you call it
See, because you are saying there is no dispute, we want to have a look.
She has not diffused, only I.
Let us see, let us.
Okay, grateful to you. 1 week given.
15th August.
Get.
Item number 2.
অনেকগুলো ডকুমেন্টস দেয়নি ওদের আমাদের একটা রিপ্লাইটাও দেওয়া হয়নি It's a case of my lord, unauthorized absent or what after going my lord, they ultimately found it to be 80 something my lord 89 days. Initially it was long days, subsequently they found to be 89 days. Or what happened my lord in this matter, my lord, the opposition or the reply filed by the department before the tribunal as also the written notes filed by both the parties, those are absent in the lordship's brief. My lord, to take the matter as a whole, my lord, may I come back with a minor punishment? May I come back with a supplementary affidavit annexing all those documents so that it can be decided?
Which documents you want to place?
My lord, the opposition filed by learned friend before by the department before the tribunal.
What is your case? Let us see.
My case.
Why?
is that
What is the infirmity in the proceeding conducted by the authority?
My case is very simple and very short. That the absent, as according to the department, is an unauthorized absent, and the charge sheet was on that regard. Some case of misconduct, that is why minor penalty. My case is that From time to time, I file leave applications. And when I did not file leave application, after joining, I file application for my lord honoring the leave. These documents, according to the petitioner before the tribunal and as also before the disciplinary authority, has not been considered. My lord, they came to a conclusion, that is the inquiry report. Inquiry report, my lord, kindly comes. It is, my lord, page 111. The inquiry report, according to the inquiry officer, report is very only 2 pages report. That is at 114. That he has found that charges are correct and came to a conclusion.
Where is the charge memo, please?
9 of the '58. Statement 59. And my lord has got it.
Charge memo is at page
59.
and the inquiry report is
Page 111.
11.
11.
111.
The relevant part is at 114 and 115.
No, where's the question of inquiry report? This is under Rule 16. So Rule 16 is there is an inquiry conducted.
There is an inquiry conducted. But my case is very short.
No, where is when the inquiry there was any presenting officer was also appointed. For a minor punishment, they conducted the inquiry. You filed any representation against the inquiry report?
Yes, before that also we tried to explain.
Where is that representation?
Fine, fine. Okay. Five, Mara, kindly first come to page 55, 65, 65.
Where are the applications?
Whose, my lord, I have asked for, my lord, that is, my lord, not annex, but I'll come up with that one.
No, no, how can you come up here? If you have not produced it in the inquiry rightly, they have not considered.
It was produced, my lord. It was produced, my lord. I'll satisfy your lordship, my lord.
Where is it produced? We don't find it.
I need a day, my lord. I need a day, my lord. Because my endeavor, I'm telling your lordship, my submission, my crux of my submission is very, very short, my lord. For unauthorized leave or unauthorized absent, my lord, it does not tantamount to misconduct unless it is proved to be willful.
Therefore, we are saying, where are the applications? If you have not submitted application, then it is
Was
willful.
submitted, my lord. May I come back, my lord? Give me a 2-3 days time, or I'll come back. Everything is whatever there is on record. I'll refer from that only.
But why don't you come with all the things to begin with?
Yes, my lord, it is my fault. I take the responsibility, my lord. It's my fault. My lord, kindly sees the order of the tribunal once. Nothing has been dealt with. Nothing has been uttered. Up to page 5, facts have been reiterated. Thereafter, few judgments have been quoted on the position of law.
Where is your representation again? Just show us once. Against the inquiry report?
Sixteen.
No, it seems you have not submitted any applications.
My lord, from the inquiry report, my lord, kindly see page 116. My
Yes, let us see. Where does it refer to your applications? Because nowhere have you mentioned the detail of even one application. Not one application detail is given by you. The last opportunity was given by you to submit the applications on 3/12/13 in a proceedings on 21/11/13, which is signed by you. That means till that date you had not submitted. Otherwise, you would have objected to such adjournment. Next date also you have not submitted anything. And obviously, because if you had submitted any applications, you would have been saying that these are the applications dated so and so.
Yes.
You don't say anything.
No.
You only say I have submitted applications. That's all.
Applications have been referred to. 116 also, it has been referred as to the applications.
Huh?
116, my lord.
Yes,
Yes.
but you have not submitted. It is apparent from the proceedings. You come to page 106. On that day, the inquiry officer granted you time till 3/12/13 to submit the applications. You are not submitted. If this was incorrect, you would have questioned such a recording. You would not have signed it. So prior to this, you have not submitted that you cannot dispute. After this also, you have not submitted.
I inquired it from the petition and during.
We'll go by the records.
Yes, my lord. What happened, my lord, regarding applications, the parties, the employees, they do not they are not given the copies of the applications. Copies once submitted, that is the
Very
one.
nice, very nice, very nice.
And at some point.
So where have you said, then how you have said you will give the copy? You can't take both stands that I will give and you don't have a copy. You can't say both things.
The service book also, that also copy I have.
Service book is something else. Your whole case is founded on the submission that absence becomes unauthorized if it is without obtaining a leave or intimation. So the sole question is whether you submitted any application whatsoever. Till 21/11/13, you had not submitted any application. After that also, we don't find anything. Now, under the circumstance, this looking into the procedure adopted by the inquiry, what remains for us in a writ jurisdiction?
So the service book also recorded the.
We don't know. We don't know. We don't know.
May I come back one? Because the service book also records that my presence, I was there. It was.
Service book does not record these things, sir. It will either be apparent from the attendance register or it will be apparent from your application. If you are alleging any kind of malified or bias, then you are to substantiate it with your application, which you have not given. The attendance register, they have brought in the inquiry. So what is a service book? Service book means nothing.
My endeavor, my lord, before your lordship is there to show that
This is, we
was
think,
not willful at all. It was not willful at all.
but you can't. The only thing is, with reference to this document, we can't make out. Nobody can make out that any application was submitted. Such a finding would be perverse if we were to find that there is an application. Can't be, simply can't be.
But may just give me another opportunity, 2-3 days time, my lord.
For what? What will you show us?
Give a supplementary affidavit.
No, no, no. We will not give any. We are not allowing you liberty to file any supplementary affidavit.
What is there on record, I'll rely upon that only. Nothing else. Nothing on my lord, what is not submitted before the inquiry officer or before the proceedings.
There's nothing, sir. Just see 3 dates you have. They have allowed you to give the applications. You have not given an application. Not a single application. Only by saying that I have submitted applications, you want to get over absence of 80 some days. As if it is up to you to leave the office whenever you.
Any day, my lord.
Punishment also is very commensurate. It is just withholding of 3 increments. That also without cumulative effect.
I'm not on that, my lord. Only on the principle that whether they could prove that it is.
See, first thing is we are not hearing an appeal.
No, certainly not, my lord.
So therefore, we have to see whether procedure has been complied.
Yes.
Procedural lapse, we don't find any. if it is a case that a material has not been considered, then we may look into it. But you have not given the material. We cannot make such a conclusion
May I come?
that you have placed the material. Where is the question of not looking into it?
We just give it to.
You are signing this proceedings of 12, 11, 13. And prior to that, you have given an application that a response saying that I am giving the applications. So obviously you are stating incorrectly. You have said there also that I am giving the applications, but you have not given. Thereafter, they gave you 3 opportunities. Still, you have not given. So the falsity is writ large. Your pattern of remains. What will you show?
Any day, my lord. Any day, another so give me something.
No supplementary. What supplementary?
My lord, something I want to, my lord, whatever is there, whatever submitted, nothing else. Not a single document which are not submitted before the disciplinary authority. I'll not do that. Only that much. See, tanker, nothing else.
Submitted or not?
It's
It appears prima facie we are not satisfied. If you come with something, we don't know. Let's see.
on review.
Item number 3.
Outside my lord, I submit, my lord, I have filed, submitted before the planet government leader I have served. I have prepared the, my lord, individual I cannot, my lord, officers I cannot serve because of the postal disturbances. My lord, I tried. My lord, Mr. Jawaharlal Day is appearing for the response. All of them are state respondents. I have served the planet office of the government. My lord, this is a matter relating to compassionate appointment. I am son of the person concerned.
Why it has been rejected?
My lord, has been only rejected only on the ground that I have submitted the pro forma application after the period of 2 years. My lord, I draw your lordship's attention, my lord, this case I have, my lord, argued before the Learned Tribunal, my lord.
What was the date of unfortunate demise of your father?
My lord, that is 3/11/2015.
Your application?
I submitted a plain paper application on
Yes.
2/3/2016. My lord will find from, my lord, page.
No, is submission.
Not kindly see the page 46. It's a stamped copy of the T. So it's not in, my lord, prescribed pro forma. Page 46, my lord.
How can I understand what you have written?
This, my lord, received by the executive.
You have to be kind to me.
I will, my lord, translate it.
I don't understand.
My lord, my whole contention.
Just give us a minute.
My lord, thereafter. Yes.
This application is after 26 EMP.
Yes.
So you are relying on 26 EMP.
26 EMP BB. My lord.
Yes, that's why.
BB.
Yes.
BB I am relying. My lord,
Yes.
there is a specific, my lord, submission on my behalf, my lord. I have specifically submitted before the tribunal that it is the duty on the part of the authority to guide me.
Yes, under 26 EMP, it has become explicit. Although if it's a compassionate appointment,
My lord,
they should do it anyway. So, who is appearing? You know?
Yes, my lord, Mr. Jawaharlal Day, my lord, I just talked with him. Lord, he probably, my lord, is engaged.
Did they file a reply before the tribunal?
No, nothing.
Have you taken this ground regarding 26
Yes, my lord,
EMP?
my lord, the order, my lord, I have, my lord, stated in the during the course of submission. My lord, kindly sees the order sheet. Last 4 lines. Though a plain paper application was submitted and received by the office of the respondent authorities, but the impugned rejection fails to mention this important fact. The reference was made to clause 10 BB of 26 EMP dated notification dated 20, which has been specifically, it has been specifically stated it is the responsibility of the respondent authority to help and guide the family members of the deceased employee. My lord, here, my lord will find after the superintending engineer, my lord, returned the file, they have kept silent for 1.5 years.
Somebody has entered appearance on behalf of the state.
My lord, I have been told, my lord, that he is appearing. He was just here, my lord. He probably has gone to courtroom number 8, my lord, as he has informed me. My lord, can it be taken up tomorrow, my lord? I will give another letter to him. He has stated, my lord, I have served the government leader and he has stated that he has instruction to appear on behalf of the state. And all the state's responsibilities are there.
Not today.
Either.
Item number 4.
Maybe it's Lordship.
I think Mr. Malik is appearing.
Yes.
Yes. The matter relates to hostel mess workers attached to the medical colleges. Now, for a moment, if your lordship kindly turn to page 126 for once, this was the initial order passed by the tribunal asking the government to decide over the issue. Lordship is on page 126.
Your matter is still pending. Why?
Why? Yeah, why? Now, if your lordship be with me, this was filed in 2016. Now, if your lordship kindly turn to page 126, kindly give me 5 minutes to place the issues in a nutshell. Now,
First the issue, why? Then we'll come to the issue.
yes, for that, this is required. This is required.
What is it? Tell us.
Issue is with regard to hostel mess workers who are working in the medical colleges. Now, this was the order being passed by the tribunal, asked the government to decide over the issue. The very next page reveals that this was put forward before the finance along with the hostel mess workers who works with the higher education department. Now,
And you are with which department?
I am with medical colleges. Both were sent forward. Lordship will find the same from page 128.
No, we are asking you why during pendency we should take it.
I'm coming. Until and unless I place this facts, Lordship will find this has been pending over there for years. 37 times this matter appeared, for which I came before this court. And Lordship will find on page 332.
Yes.
That is Justice Tandon's order. Lordship, kindly have a look what is being stated out here.
332.
332. Kindly have a look at this order, which was passed by Justice Tandon while he was entertaining this matter. Issue is settled up to Supreme Court. Other departments has been assured with the benefits. They have been blessed with the regularization as well as the pension or other ancillaries as available to the non-teaching staffs. Kindly be with me on page 332 for once.
That is precisely what the other bench also held, that you have to go
now, when it was passed, kindly have a look, it's 2023.
Yes.
What is the direction of the bench earlier?
Yes.
We expect, as Press 335 reveals.
You filed any application before the tribunal?
Yes, thereafter this matter rolled before the tribunal placed.
Where is the application filed placing on record this observation of the High Court?
Yes, Lordship, may I have a look on this page, the very next page, 336.
That is not the application.
Yes, Lordship, may I kindly have a look at the order being passed by the tribunal? Learned counsel for the applicant, very last line, refers to the order dated such and submits that as directed by the High Court, the matter may be heard and logical conclusion reached by the tribunal within 1 month. The learned tribunal expresses inability to hear and conclude this member within such and such. Further, it is observation of this single matter relating to regularization of 153 applicants involving various points of law and heard by earlier division bench. Therefore, this matter should be placed before such a bench. And we tried out, Lordship. We tried all up subsequently, Lordship will find the very next bench, very next page. Now, since this is the regulation involving 153 and the learned tribunal is not manned with more than one, I can't be more explicit. Until and unless Lordship.
Once you have obtained an order from a court, a mandate,
Yes.
if it is not complied, what is to be done?
Contempt against.
We don't know.
No, this will unnecessarily. Well, Lordship kindly takes up my matter. This issue is already
See,
settled.
for you, it is very easy to say, but
But
can we open such a procedure now that whenever there is a non-compliance, a successive writ petition should be filed?
Until and unless Lordship feels, be with me for 1 minute. But 16 the orders. All departments have already complied. I personally been successful up to Supreme Court.
We are not hearing you on merits. We have told you
True,
at the beginning.
True. But Lordship is hearing a writ petition.
We are not entering the merits right now. The point
But
is,
Lordship, I cannot be remediless also.
you don't know whether you are remediless. You have got an order of the High Court.
High Court, but if it is not being done, what is being stated? Lordship, kindly give me 5 minutes to hear. Lordship, be with me 1 minute. Even on 2024, I placed the matter before.
Shall take up. Just read the last paragraph of the High Court's order.
Yes, shall take up.
Yes.
It's a mandate.
Then
thereafter it is being thrashed.
Therefore, you come for a second writ.
In fact, to be honest, Lordship, be with me for 130.
And if we pass an order and nobody complies, you file a third writ petition. Can we? Please try to understand what we are saying.
What's falling from your Lordship's mind, I follow, but
yes,
this is really very.
It is.
It's after all,
does not
a judicial discipline, my lord.
You don't know.
But kindly be with me for 32 once. In fact, it has been stated and marked by my Lord Justice Tandon.
Yes.
May I read for Lordship for 1 minute?
It
has been vociferously submitted, Mr. Banerjee, the tribunal non-functional answered that any direction passed by this court will not be respected nor be adhered to. I told on the very day, even though he trusted, to be honest. Even then, this is the situation after 2 years of lapse, and I am being given rolling like a shuttlecock. Sometimes he says 2 persons are not, the 2 persons will never be there. What we will do, my lord? Kindly feel this side. She was also there. 13 persons.
Point is, the moment we do it in one case, for us, we'll have to do it in every case. Can we start this? In view of the mandate in L. Chandra Kumar.
This will be unending Vyasta then.
Please try to understand, assist us on this, how we can do this.
But he is telling until unless 2 persons will be there, yes, I am not in a position to decide. That proves that this is non-functional. On that material day when Justice Tandon passed the order, that was not the situation. Now he explicitly marked in his order.
What is the date of the High Court's order?
Yes, my lord, the lordship will find. This is 24th of April, 2023. This is practically, we are hitting this time's puja. 2.5 years of last for with all these things. Let me lose. But at least I should be honest to my client. What I am doing.
How can we?
That is the reason why I'm hitting the doors twice. filing with such a voluminous petition. Until and lordship stretch your hand, we won't be getting anything. This will be the situation. I may lose, that's a different thing. But I know I should be getting a reason to lose.
Time limit has also been fixed.
What to say, Malak? What to say? I can't be more vocal. Being more vocal would speak something else. But if your lordship kindly turn for 129 for once, then nothing remains, to be honest. Unnecessarily, I'm being shattered. Kindly have a look at page 129. Once, just.
So the High Court directed within a month.
Yes.
You have waited for how many years?
No, that lordship,
years.
kindly be with me. Kindly be with me. How many times I have visited thereafter also?
Therefore, we are saying if you are armed with an order specifying a time frame and which says 1 month, you wait for 2 years.
No, not only 2 years. He said, kindly have a look at the order. First, he says, I am a single bench. I cannot hear it. This is a huge issue. To be honest, I'm not that much courageous enough to hear it. To be honest, I'm keeping myself mum for 2 minutes. But this time, I should be more vocal. Now, thereafter, he says, okay, I can hear it. Kindly have a look. That is also being there.
Why you have waited for 2 years? And if you could have waited for 2 years, wait for some more time.
No, can't be. There is no vacancy. What he's stating? He's stating, I cannot hear it since I'm a single member. This is a huge issue being pending. This is a 153 people regularization, out of which already 16 has went for heavenly abode. This will never be heard. This will be a natural death. Repeated matters I have filed with regard to other departments.
Who is appearing for the state? Well, then opposition will see. We'll leave the issue of maintainability open. You can raise all issues. Leaving the issue of maintainability of the writ petition.
Lordship was granted us for exchange of affidavits.
Let them file, let's see.
We'll be supplying a reply to that also. We'll be supplying. Because since the Lordship is posting it after vacation.
The affidavit.
Item number 5.
5, I'm for the petition.
filing the affidavit of service. জিজ্ঞেস করে ফাইল করো, ওনাদের জিজ্ঞেস করে ফাইল। Kindly come to the order impugned first.
Come to
Order impugned, which is at page 184. একটু সাইড দিয়ে বস, এখানে দাঁড়া।
where is
Kindly
the
come to-
order that you challenge? Where is the impugned order?
Kindly see the impugned notice I have challenged, which is page 140, page 140. The inquiry proceedings has been initiated against the petitioner without serving me charge sheet,
Charge sheet
without
to a contractual employee.
contractual. Kindly see the page 46 once. Page 46.
No, are you a contractual employee?
Contractual time to time extended.
So the West Bengal service rules will apply to
WBCS.
you for a proceeding.
Not absolutely not, but page
Then?
kindly come to page 46 once.
Yes.
And page 46, the letter of appointment of the petitioner, which is issued by the.
No, we are not on that. Ultimately, what is the prejudice by the order? Therefore, we are looking at it. This is an order. It is a contractual.
Just
Whether
next, I am the
you will be governed by the terms of contract for 12 months.
that is time to time extended.
Whatever.
What has happened? In the year of 2009, I was appointed as a block accounts officer, manager of the block. Thereafter, on 11 December 2024,
Where is your contract between you and the
page 46, where is it is particularly mentioned that, may I read the block accounts manager is being engaged on the contractual basis for period of 11
11
months on 1st December 2009. She should execute a bond in the stamp paper at the time of engagement, respective BMH and the block health and family welfare committee. Now, the block accounts manager will work in BPHC under the control of BMOH. What has happened? On 11 December 2024, at the working hours, a incident of condemnation of files has been happened without my consent from the Almira of the petitioners. Petitioner wrote several intimation to the authorities. They did not take any steps. Kindly come to page 53 once.
That's not the point. The point is that such disengagement or termination of your contractual relationship, what is the right?
But the inquiry
That's the only thing that we have to
inquiry
see.
might not initiated by the chief medical officer. Kindly
There's a question of inquiry. Therefore, we are asking you.
Page
It is at
60 and-
best a show cause is to be issued. There is
Yes.
no question.
that is the question, page 60 and 61. I have not committed any wrong from my Almeria without my knowledge.
We
Condemnation
don't
of
know.
my-
We are not going to look into the allegations.
Page-
We are
page-
just on the
Kindly
procedure.
come to page 60, 61.
Yes.
This is the page 60, 61. This is the preliminary inquiry report initiated by the block medical officer health.
That is something done by them within the inquiry. For that is not including you. You are only issued a show cause. Where is the show cause? Show us.
Cause has been issued, which is at page 135.
That is all. That is from where the story starts. For
No, inquiry has been started against me also. Page 85 also. Kindly consider page 85 first. Page 85.
There is an inquiry against you.
Yes, page 85. Kindly see page 85.
85.
This is the order dated 23rd December 2024. Constitution of Inquiry Committee. And I am the block accounts manager of Ghutia Sharif. kindly see the allegation by worker organization alleging misbehavior and corruption against the BM block accounts manager. And kindly come to page 86.
They are conducting a fact-finding kind of an inquiry. This has
Sir,
nothing
after
to do
my-
with you.
After my representation and complaint, they initiated the
Point
constituted
is,
the
what
committee.
is your right? That is all. You can only maintain any issue with reference to your right. You are a contractual existence in the department.
Absolutely.
The West Bengal service rules has no application. Neither 311 will apply to you. Whether the contract contemplates that any notice period is there or 1 month's salary has to be paid, if that is all, then beyond that, you will not be in a position to
My
maintain any
contention
cause
in
of
the writ petition is that my contention in the writ petition that I have not involved in the condemnation of the file. Someone involved in the condemnation of the
Maybe
file.
we don't know.
I just
Where is the
intimated-
finding that you are involved?
I just intimated the fact to the authority.
Where
Subsequently,
is the finding that you are involved in the impugned order? Show us.
kindly see page 140. Kindly see.
Yes. There is
This
nothing
issue of
about
cause
there
and
is,
letter.
there is
But
nothing
why
about
caution?
condemnation.
Why caution? If I have not committed anything wrong, then why caution to me?
So you are still continuing.
Still, what has happened after filing the original application? Kindly see the page 121. Kindly see page 121. The hardship I am facing, page 121. The order of detailment was passed on 11th March 2025. Miss Mashum Maiti, block accounts manager, Khutia Sharif, Canning 1 block number is temporarily detailed to the office until further order. And I am instructed to join in another office.
Yes, sorry. 121.
1/3/21. The order of detailment and give a direction to me to join in the another office. Thereafter, kindly see, this is the order.
How
dated-
can you be aggrieved by these
Kindly
things?
consider, this is order
Yes.
dated 11th March 2020, 11th March 2025.
Yes.
On the next month, 17th April 2025, another order of detailment, which is at 124, after filing the original application before the tribunal. I just challenge the caution on the ground. I have not committed any wrong. Why caution to me?
Page?
Page 124. This is 17th April, within 1 month. Another detailment. And that is the result, my lord, just to intimate the authority that detailed condemnation was done without knowledge.
So which is the order which you challenged before the tribunal?
Tribunal, the notice of caution to me, 140.
So they cannot issue a caution to you. This is your submission.
Yes, I have not committed any wrong.
And the tribunal will look into it.
No, tribunal, kindly see page 140.
No, the tribunal will look into it. Is the tribunal an appellate forum?
But tribunal has to, my lord, say anything, my lord, regarding, my lord, my involvement in
So what is it that you're trying to agitate? Who will examine whether this caution letter is valid or invalid?
kindly see, this is
This is issued by a CMO.
CMO.
There must be a higher official. Please try to understand what we are saying.
Appellate authority.
Who will examine whether it is due or undue? There is no question of violation of any procedure. No rule applies to you. So if you are disputing the correctness, can the tribunal look into the correctness as an appellate forum?
But that
That cannot be done. The tribunal cannot exercise judicial review because there is no rule applicable to you.
But this
So
situation
what
that,
is,
my lord,
that's why we are saying what's wrong with the tribunal's order.
facing day-to-day detailment order.
You must,
subsequently-
we don't know. It may be a valid condemnation. It may be invalid. Both options are there. We can't take it that it is undue.
Nothing, the
We can't
findings-
take it that it is due. The point is who will examine? The tribunal or the writ court? So there must be someone above the CMOH. Why don't you avail the remedy?
Let them, my lord, kindly.
Who is above the CMOH? Who is the next?
Let her, my lord, let her submit, my lord.
Yes,
Is the appellate authority or
Yes, sir, the secretary is there. Above the
secretary.
secretary is there.
What can we do?
and kindly, my lord, the order of detailment kindly.
Nothing. Will not say.
Item number 6.
Met with the Shilach. I beg to appear with the respondent original applicant. Kindly sees my lord's last order.
Pattern Mr. Sopon Kumar Nandi is appearing for the petitioner, my lord. He is in tribunal, my lord. He is coming, my lord. I'm praying for only Passover, my lord. Or
Then not, no Passover, not today. We'll take it up tomorrow. Tomorrow call this matter.
Okay.
It's okay with tomorrow is all right with you. Okay.
Seven.
For the petitioner, my lord. The last occasion, my lord heard my lord junior Mr. Mudimdar almost complete one judgment. Wanted to see that's delivered by Justice Chief Justice or Chief Justice Judgment Bench on 9 July 2025. This I'm handing out the copy. Copy.
Paragraph 9.
Paragraph 9, my lord, can see. This is an
Extra copy থাকলে আমাকে দিও original.
and this is and these two are my lord P. Gunasekharan, the judgment is referred to.
Paragraph 12 and 13.
And P Gunasevan, paragraph 12 and 13. Can you see? And then 7. Eight, 12 and 13.
Paragraph 9. On the discipline, and the discipline consists paragraph 9. The discipline of the paramilitary forces and armed forces cannot be equated to that of the civil force.
The last judgment, my lord, I refer to last occasion, but my learned junior had no hard copy. My lord wanted to keep the hard copy of this. I have handed over. Then paragraph 9 of the judgment. Can you see Akbar? I have seen. We need to point out that the level of discipline to be followed by a member of paramilitary force is the last one, unreported, is much higher than that of any other civil employee.
Well established. It's not something new. It is repeatedly courts have held. Armed forces, banking service, all these services
Yes.
require a higher level of scrutiny in the matter of punishment.
দেখতে পাচ্ছি না। দেবেন Kindly come to page 97. Security standing order. Page 97. Security was manning the tunnel gate. No. 6, 1, 2, 3, 6. Area of responsibility. The post is situated on north side of the MD office, nearby the gate where are two water bring and south yard railway crossing. It is 400 meters from MD office. Criminal may enter through this gate. It was known that may enter. He knew.
What does this mean? Just see what it says.
Yes.
The post is situated on north side from the MD office.
Yes.
Nearby the gate, there are two water bring. What does that mean?
Two tunnel gates are there. My lord, in gate out.
Water bring.
Tower. It post is situated north side of the MD office, nearby the gate where there are two water bring. Water towers.
What is the meaning of water bring?
Bring. So what water towers? Maybe tank. Water towers. South yard of railway crossing. It is 400 meters from the MD office. Now, my lord,
it is 400 meters from MD office. Criminal may enter through this gate. What does this mean?
Caution. What is the abandoned caution? It was there. Instruction was there. Now, when it comes to page.
So this is the role assigned to the CISF. CISF unit Burnpur.
Yes, my lord.
This is a standing order issued to the CISF unit of Burnpur.
ISP Burnpur security standing order.
Correct. So it is the CISF has been asked to look after the security of this.
Yes.
This is for the tunnel. This is a standing order.
This standing order for only tunnel gates. Tunnel gate purposes. Tunnel gate. He was on duty in the tunnel gate. My lord, then comes to page 87.
And this petitioner was a constable.
Yes. Constable. Now, my lord, then comes to page 87. $118, my lord, not $118. Karamir Kadam. Answer. Answer. Now, question put to Ravi Kumar. Which force member gave permission to the vehicle shown in the CCTV footage to enter the plant? Answer. Constable Ravi Kumar. Did Constable Ravi Kumar conduct security check of the vehicle before it entered the plant? Answer. In the video footage,
which
Constable
page?
Page 118, my lord.
81.
118. Question number 2, which force member gave permission to the vehicle shown in the CCTV footage to enter the plant? Constable Ravi Kumar. Answer. Constable. Did Constable Ravi Kumar conduct security check of the vehicle before it entered the plant? Answer. In the video footage, Constable Ravi Kumar is not seen doing any checking or making any queries. Number 4. Before entering the tunnel gate, how long did the said vehicle wait? Answer. The said vehicle, before entering the tunnel gate, waited for about 10 seconds. 10 seconds from 1858 to 1858. Now, does it appear from watching the video footage that at that time there was crowd at the tunnel gate? No. From the video footage, no crowd is found and the tunnel gate at the time. 10 seconds, 6 persons were checked. There, it checked 6 persons and along with the vehicle within 10 seconds. And along with the vehicle. And it shows how he was negligent. 10 seconds is over. दाखव. Now, page 127, question was put. Can the security check of a vehicle be done in 10 seconds? Answer no. How much time it takes to do a normal checking of a vehicle? Answer about 2 to 3 minutes. Well, this has been considered by the 3 authorities, divisional authority, then appellate authority. Now, they found it against the petitioner and imposed punishment. Now, at this stage, whether High Court had reason to reappreciate the evidence, reappreciate the evidence. Yeah, yeah. Last occasion, my lord, Mr. Moondar had concluded his submissions. Only my lord wanted to see this hard copy of the judgment by the my lord the Chief Justice. They had to give reply.
सर अपना शेष है
That's my.
I hope my learned friend, senior friend, completed his submissions in respect of the.
Yes, he has said that.
So the before going to the portion of law which has been enunciated by learned friend in his appeal, just I took only 3 or 4 minutes time, so that your lordship just recapitulated the factual aspects, so that your lordship can, although your lordship will aware, Lord, in respect of a vehicle which has been passing through a gate where a security team was formed by the CISF officials to look after the existing and entries, my lord, the gate. One sub-inspector, one ASI, and one constable. Those higher officials.
One constable or two constables?
Two constable, one inside and one other side. 3 of the officials, 2 official, including one constable, is outside. They are maintaining the formalities, and I was inside. According to the charge that the vehicle was entered, I have not been carefully checked the vehicles or check the pass. After that, the vehicle was intercepted by others constable. Thereafter, according to the allegations, out of 6 miscreants, 3 was fled away and 3 was nabbed by the other officials of the CISF. Thereafter, a police case has been lodged against the incident. Thereafter, subsequently, I came to learn that all are acquitted from the allegations which has been leveled against them. Now, my lord, on the basis of that incident,
all acquitted, including you.
Those are the nabbed by the CISF official in respect of the vehicles.
So they have all been acquitted.
Now, my lord, on the basis of that incident, a preliminary inquiry was conducted by the officials. My lord, in the preliminary inquiry, the deposition has been taken from the respective eyewitnesses as well as those are the engaged on the particular date. Thereafter, my lord, after taking into considerations of the depositions, a report was prepared by the higher officials which has been submitted before the disciplinary authority. My contention before lordship that 2 copies of the depositions has been annexed, but the report of the inquiry officers of the preliminary inquiry was not been furnished to me. And on the basis of that, the disciplinary authority frame his mind and, my lord, a charge was leveled against the charge officials. Thereafter, Lordship,
Is
charge-
there a requirement in the procedure that before framing the charge, copy has to be given to you?
Lord, if my lord, or subject correct your lordship, my lord, following the question before lordship, my lord, when you frame your mind that the allegation was justified allegations or this allegation is required to be, my lord, ascertained through a departmental proceeding. In that event, when they relied the, my lord, preliminary inquiries version, my lord, opinion for draw a proceeding against me, in that event, at least a copy of the preliminary report should be given to me.
So therefore, we are asking you, where is this requirement?
In respect of the departmental proceedings, those documentary evidence has been relied by the authority. That document has to be supplied. My lord, this is the cardinal principle of the rules.
That's not the point.
Lordship.
The point is that before framing of charge, whatever material has been considered, that has to be given to you.
No, my contention subject to kind sanction. Don't take my
Yes.
lordship. My lord, when the charge was framed against me, then in the charge sheet they relied the documents. So at that point of time, they
Where have they relied on the document? Show from the charge sheet. Where have they referred to anything from the preliminary inquiry?
if your lordship take trouble to the page 89.
Yes, we are at
I'm
page
referring to lordship because
Yes.
your lordship last occasion also asked me.
Yes.
But there, they have mentioned that the statement of Constable G.D. Ramnath recorded during preliminary inquiry.
So this is the one of the list of documents. Yes.
I got your lordship's point.
Yes.
I tried to assist, being officer of the court, that the depositions of the different person has been collected by the competent officers who has been inducted by the disciplinary authority to make an inquiry whether the allegation is genuine or not. You report. And on the basis of collective evidence from the respective G.D. Nath, thereafter my lord Sunil Rai, thereafter he has prepared a report and report has been submitted before the disciplinary authority. And on the basis of report, my lord, a charge was framed against me. So I am asking, my lord, this is a cardinal principle of law, because my lord, if you rely that the preliminary inquiry before framing of a charge, you ought to have given a copy to the petitioners that or in the charge sheet that this preliminary report was on the basis of this charge frame, lordship. My contention before lordship.
You are saying it in many different ways. What we want to see is where is the requirement? Because what the point you are raising is essentially an issue of principles of natural justice.
Correct, lordship.
Natural justice is not to be put in a straitjacket formula.
Correct, lordship.
It cannot be applied everywhere.
Lordship.
Only when there is a prejudice or with an action is to result in a civil consequence, then rules of natural justice have to be applied.
Lordship.
Before framing a charge, whatever material has been seen, if they have relied upon two statements, they have given it to you. According to you, the entire file should have been given to you.
No.
Yes, because the inquiry report will contain everything.
Only, my lord, the inquiry, my lord, my humble submission.
That will contain everything. So therefore, we wonder what is the prejudice by non-submission of the entire records or the inquiry report or the preliminary inquiry report, and mere issuance of charge memo, does it cause a prejudice which requires compliance with principles of natural justice? So we are asking you,
correct,
either it is in the procedure, if not, show us some law.
my lord, I am assisting the lordship, my lord, that pausing 1 minute, my lord, subject to kind sanction, this query is concerned, which is falling from your lordship. That whether the preliminary inquiry is were to be given to the petitioner in absence of supply of the preliminary inquiry report, what would be the consequence? Whether it is stated to be a violation of natural justice or not, because your lordship, my lord, just suggests that there is no straitjacket formula that in every case is that, my lord, the violation of principal justice will be attract. My case is here, my lord, because the three others security personnel, they are look after the entry into the gate. I was inside. And on the basis of the entrance of a vehicle, which has not been, my lord, clearly disclosed by any iota of evidence by the prosecution sides, a major punishment of dismissal or removal from service, which was inflicted upon me. My lord, I come up before lordship, my lord, before the trial court, that the proceeding which was concluded in contrary to the provisions of the CISF Act, as well as violation of the principle of natural justice, as well as the punishment which has been inflicted upon thee doesn't commensurate with the incident, charge, and the allegations followed by the, my lord, major and harsh punishment. My lord, I try to assess your lordship because so far your lordship's query is concerned. I just, my lord, now my lord, one second. So for the departmental proceeding is concerned, your lordship will aware, and a procedure which has been laid down in respect to departmental proceeding, how to be furnished, how to be continued, and it is elaborate, my lord, mentioning that if the departmental proceeding and non-supply of the, my lord, preliminary report or the inquiry report which has been relied by the authority concerned is procedural irregularities in respect of conducting a departmental proceeding. This has been enunciated in the Ramzan Khan's case versus Union of India.
Preliminary inquiry. In Ramzan Khan, submission of inquiry report.
Inquiry report.
Yes.
As well as the
Preliminary inquiry.
My submission before lordship, because
when you are relying on a judgment, you must be covered by the judgment. We don't recollect that in Ramzan Khan there is a mandate that preliminary inquiry has to be heard.
I'm coming, lordship.
Yes.
So
neither in Ramzan Khan nor in ECIL versus Karnakar. Neither of the two judgments. These judgments are on the issue of giving a copy of the inquiry
report. Mostly, lordship.
Yes. Not mostly. That is the only thing. It does not say about preliminary inquiry.
Lord, I can assess the lordship. So for the preliminary inquiry report is concerned.
Yes.
Now, my lord, one aspect. Second aspect before lordship. So for the appeal which has been presented before lordship, that the
we are not hearing an appeal. This is a writ petition.
My lord, stand corrected. My lord, so far the copy is concerned. My lord, this petition where my learned friend tried to establish before lordships that the departmental proceeding which has been conducted by the prosecutions has been correctly dealt with the entire matter according to the charge which has been leveled against the charge officials. My lord, my contention before lordship, except page 87, if your lordship take trouble to the once again, inner page 118, my lord, sorry, stand corrected, my lord, page 118. Page 118, my learned friend refer, and your lordship also, my lord, mark it lordship. Your lordship got it?
Yes.
My submission before lordship, except this 2-page, no other any contention, depositions, evidence has been, my lord, derived during the course of departmental proceeding, wherefrom it could be ascertained the charges are proved against the charge officials. my lord, subject to kind sanction, my lord. If I, my lord, miss anything, your lordship can, my lord, repeat. But so, and my lord, this, except this submission, my lord, documents, no other documentations has been annexed in the four corner of the writ petition. Now, my lord, who is he? My lord, stand corrected, subject to kind sanction. He is an operator of and maintaining the, my lord, CCTVs sitting inside the room. He is not eyewitnesses. He was not present in the place of occurrence. Even his CCTV doesn't disclose the model of, my lord, vehicle, manufacture of vehicle, number of vehicle, how many people are sitting in the car, and even the color of the car has not been, my lord, clearly depicted. But he ascertained. Even he has been, my lord, mentioning in the answering in the depositions, it is not clear. But as per Ravi Kumar has been done. So for the no evidence is concerned, my lord, I am asking this question to myself, my lord, subject to kind sanction, my lord, that except page 118 and 119, where, my lord, 5 question was put forth to the Dharambir Kadam, and in reply to the queries, my lord, his answer. So for the other answer is, my lord, not at all any relevancy with regard to the same. 7 except the name. Kindly, my lord, consider. And the security of the gate, it is a collective effort of a security team consisting of 4 members. But so far the Dharambir Kadam's statement in respect of query number 2 is concerned, he has been isolating me from the team. And he has been marrying my name only without any basis, without any evidence, without any CCTV footage. And shifted the entire responsibility upon me. Your lordship, kindly visualize. I am just completing my, my lord, Cobra training, and that day I have been joined in the, my lord, unit. On that day I have been deported in the gate. No worry. I mean, in discipline force, I have to be perform my duty.
Disciplinary authorities order is 28/2/14.
Page
177.
lordship. Lordship. Final order. Continue up to 187. Your lordship, right click. And appellate authority order, my lord, page 208. and revisional order, my lord, 215.
Two 25.
Lordship.
Two one five.
215. Last operative portion 219.
No, revisional authorities order.
Order, my lord, just.
Yes, 215 is the revisional. You have not, neither of you have shown the CISF Act or rules.
Lordship, I have.
Last day also we had asked. Where is the,
Lordship. My lord, here,
yes.
one question of law, my lord, before,
Yes.
my lord, in normal cases, if the charge official failed to appear, my lord, I am relying the procedure 36, section 36,
Rule 36.
rule, no, section 36, sub rule 10, my lord, subsection B. Your lordship got it? My lord, here, last occasion,
But there is no section.
sorry, I mean 36 written.
So it is rule 36.
Rule, that is rule.
Yeah, now stand correct.
The rule
Rule,
that
rule.
Rule 36, subsection 10 and B. My lord, in normal cases, if the charge official failed to appear and submit his written statement against the charge, in that event, the disciplinary authority, my lord, may appoint a presenting officer
Yes.
but here, without following the provisions of this section, rules 36, subsection 10, since inception of the inquiry proceedings, my lord, they have been appointed presenting officer who assists the inquiry officers. This is not at all any harm to the applicant. But so far the procedural, my lord, the process or the system, they ought to have followed while they have initiated a departmental proceeding and continued till passing the final order. Here, the charge official was duly appeared, duly furnished his documentary evidence. Even then, for abundant precautions, they have been engaged in violation the section rule 36, subsection 10. If your lordship take mark of this.
What is it? Let us see 3610. You have two copies.
Sorry, one copy. Extremely sorry. Extremely sorry. Wait, actually.
We have it.
It's in the book. দুটো কপি দিয়েছিলাম এই বইয়ের দুটো কপি দিয়েছিলাম
Lordship,
B.
Lordship B.
Yes, what are you saying, trying to submit with reference to this?
Lordship.
What is your submission?
My Lord, the inquiring authority shall,
Yes.
if the enrolled member of the force failed to appear within the specified time or refuse or omits to plead, then my Lord, require the presenting officer to proceed the evidence by which he proposed to prove the article of charge.
Yes, so
Here, after getting the charge which has been served upon me, on the stipulated date I have been replied. Thereafter, on the date fixed, I have been appeared before the my Lord, departmental proceedings hearing, and I have cooperated to my full of extent in the departmental proceedings so that the charge may not be proved against me. But here, they have framed their mind. Whatever my reply or charge is concerned, they have been mentally prepared with regard to my contention before Lordship. That one, charge preliminary inquiry was not, a report was not been given. Second, my Lord, the presenting officer has been appointed in respect to departmental proceeding. Despite the rules, section 36, subsection 10, subsection B says, my Lord, otherwise.
So according to you, only if you did not appear, then presenting officer could have been appointed. Then what is the meaning of 36(5)(c)?
Lordship.
That is the procedure for the presenting officer to start, not to appoint a presenting officer. He is appointed much earlier under 36(5).
Lordship, just if your Lordship refer me that I am reading your Lordship, subject to kind.
Yes.
Where the disciplinary authority itself inquire into the article of charge or appoint an inquiring authority for holding any inquiry into such charge, it may, by an order, appoint a member of the force to be known as the presenting officer to present on its behalf the case in support of the article of charges.
Correct. So the power to appoint is under 36(5). This is a procedure that if he doesn't appear, then presenting officer will start.
Continue, and my Lord, he will present the case.
He will start. The thing is, if you don't appear, he will start. Not that he will be appointed then. He is appointed much earlier. He has to be. Without presenting officer, how inquiry can be conducted? Whether you appear or you don't appear, it is settled law. Presenting officer has to present the case on behalf of the department.
Lordship. Here, just I drawing the Lordship attention before Lordship. So for the Rule 36, subsection 10 is concerned.
All right. So 3610B, according to you, has been violated. What else?
It appears from the face of the first two lines. I'm reading your Lordship so that your Lordship can. Third point, I try to assist the Lordship. So far the writ petition is concerned. The page, if your Lordship take trouble to the 98. আমি সেটাকে বলার জন্য এই পেজটাকে রেফার করছি। Inquiry office presenting now in the mind of the participant to take a decision because this is from the defense of blink of an eye. I'm drawing Lordship attention the page 98 of my writ petition. Lord, only 8 lines. Should I read, my lord? Subject to kind sanction, my lord.
98.
98. Inner page 669. It is the mark as a annexer P3.
Yes. So
only just few lines, Lordship. After receipt of your direction to submit my representation, I do hereby beg to draw your kind attention that on 4th October 2013, I was performed my duty with efficiency and I was alert in my duty post. That all times, I, including my colleagues and supervisor, check all the vehicles and persons properly. That in the duty times, none of unauthorized vehicles or miscreants took entry in the plant site. Thus, I deny the imposed charges. My lord, I try to submit before Lordship that the security consisting of a performance of a team, and out of 4 personnel, 3 was engaged outside the gate and only myself in the inside the gate. So whatever the vehicle is coming.
Where have you said this?
Lord, date 25th October 2013. Date.
Where have you said there were 4 persons, 2 persons were outside, they were responsible for checking the vehicle, they were responsible for issuing the pass. It was not my responsibility to do this. Where is this stand?
Correct. I got your Lordship point. My lord, so far,
Unless the factual foundation is there, how the submission can be accepted? Where is this fact pleaded before the inquiry officer?
I try to assist your lordship. So far, your lordship query is concerned.
Yeah.
This letter was submitted before the commandant and the answer before the just page. এখানে পাওয়া যেতে পারে। If your lordship এটা নেই, এটাতে জজ সাহেবের কোয়েরিটা খুব পার্টিনেন্ট আছে, ভেরি পার্টিনেন্ট কোয়েরি। আই ট্রাই টু অ্যাসিস্ট, এখানেই পাওয়া যাবে।
Consideration not been taken into this. That is this.
ফরওয়ার্ড করছি। দাও, এখানে
You want to prepare yourself properly. You want to prepare yourself properly.
my lord, so far, my lord, the pertinent question followed me.
Not pertinent question. You are making a submission. We must have gone through the record. Then you are making
Yeah.
such a submission. How can you make a such submission unless you have seen that this fact is there? Forget about our query. Once you make the submission, you will have to show from where you are making this submission.
Lord, I try to assist your lordship in a manner that the presenting officer's findings at page 154, presenting officer's findings, it has been brief of presenting officer in the name of brief of presenting officers, where it has been mentioned that how many persons are engaged in the gate.
We are not concerned with that. You have given us a submission that there were 4 of us, 2 are outside, they are responsible for checking the pass. I am inside. I am not responsible. Where are these facts? You are telling us, unless you have said before the inquiry officer, unless you have said before the tribunal, how you can say it before us? You cannot.
Correct, lordship. Your lordship, correct.
Correct. Very good. At least you have found something that we have said to be correct. But when you have made the submission, you have not made it with reference to the records.
Lord, it is better. So for the Lord, would your lordship pleasure to take up tomorrow, 10:30?
Tell us. On tomorrow it cannot be. We take it up in the next week, go through it properly. They have already concluded for submissions on behalf of the learned counsel for the response.
August. Only pending matter, so can stay.
Thank you, sir. My lord, grateful.
Item number 9.
Number 9 is my application, Your Lordship. Kind.
Item number 9,
Yeah.
I am appearing on behalf of the
Timing to
respondent. Allow me to appear, my lord,
No, no,
virtually.
no. Password name? Only not to do what you want. Not to do.
This is my application, Your Lordship, and in this matter, I am being led by Mr. Subhi Sanyal. Kindly grant a very short password, Your Lordship. He is arguing before the applicant. Kindly grant a short password. Kindly get a short password. That's why I'm beseeching. I need my seniors. Kindly keep it at 2 p.m. The advocate on record isn't here, Your Lordship.
Then why are you here? Don't be here. You are here with the file, you start. What is this? Every day adjournment? Last 2 days, it has been the date before last, you did not appear. Last day, you have prayed for adjournment. Today again, you start. What is this? It's not the way.
My lord, I am appearing, my lord, on behalf of the respondents.
Adjournments are not a casual thing that you can ask for an adjournment at the drop of a hat. Let us see what is the issue. You start.
Respondent, Lordship, I am appearing on behalf of the respondents, but my video has been paused from the court, my lord.
We have framed the question.
এই কারণে এটাকে পজ করে রেখেছে বলতো হোস্ট has paused, stopped.
ওখান থেকে বলুন।
আচ্ছা, my lord, on this self-same issue, consecutive writ applications have been preferred. That was pointed out by your lordship, my lord. And on that issue, my lord, my learned friend assured the court, my lord, to argue. ভিডিওটা যদি না অন করে বুঝবে কি করে, শুনতে পাচ্ছে না। এটাও মিউট করা আছে।
It is the order passed on the earlier way. Which page?
There have your lordship three rounds of litigation which was being filed into the Central Administrative Tribunal. Kindly come at the first order, page number 114. The 115 is the relevant portion. Here it states the representation of the applicant should be considered.
Page 100?
Page 114, your lordship.
114.
First round of litigation, sir.
114.
Yes, your lordship. 114.
This is the first way.
This is the first way, your lordship.
And second is at
This is the
161.
Second one is that the court has directed for consider of the application of the applicants. Then second one is the rejection order. That is at the page number 117, which was being passed by the authority.
No, that's all right. So
Speaking order.
second way is at
Second way is at 161.
160.
161.
160. Starts from 160. A16. Annexure A16.
Yes, yes, yes.
And this is the third.
This is the kindly come at the page number 162, the order of the Honorable Tribunal.
Yes.
The paragraph 9. The analogy is not comprehensible as to why the matriculate CCAA would be preferred over graduate apprentice when both have been evidently trained in the railway organization.
Yes.
Then the next paragraph. In view of the fact that minimum requirement is that of matriculation and course completed act apprenticeship certificate, and that course completed act apprenticeship may get preference over others in selection process, and the applicants, the graduated apprentices are well within the right to participate in the selection process and being considered. Then the para 11, therefore such applicants who have applied shall be allowed to participate in the examination, and based on their performance they shall be duly considered against the vacancies if nothing else stand in their way. And then the last order is the order impugned, where the applicants have appeared into the examination and they were being rejected by violating this order, your lordship. Therefore, the applicants have approached before this Central Administrative Tribunal by filing that way, and we have come by challenging that order, your lordship.
So you have seen the question that we have posed. Have you seen the query we have recorded in our order of 16/5/25? That is the issue to be responded.
That is the issue, I know, your lordship, but kindly allow my senior, your lordship. He will answer. He will answer. I can assist this much to your lordship.
This is what we wanted you to do. You have started. We have reached recess. Will come. Why should you not start? 3 times you are seeking adjournment. This is an opportunity for you. You have made some submissions. We'll hear him. Don't worry.
Deeply obliged, your lordship. Deeply obliged, your lordship.
Yes, Mr. Rai.
So your lordship rises what? I was praying for a leave to file one WPCT application on behalf of Union of India. The matter was filed, but it has been returned to us for the reason, Lord, that certified copy, which is impugned, but that is marked with blue ink as annex.
Where is it? What is the marking? Please show us.
Only annexure P3 that is marked in blue ink. That's why department has returned it.
My lord, this matter will continue after lunch, my lord.
Yes, we are coming. First two.
There are 3 2 p.m. matters.
We'll go by the list.
That's your loss. Then your loss is copy fix করবি বল না করে দি আমরা I'm prepared otherwise even with the copies.
Just let's see how long it takes. What copy?
The judgments to be cited.
So let's just call the list.
Item number 8.
No, I'm talking of the continuing matter.
Yes, we'll just after 2 p.m. matter we'll take.
My lord, I am for the respondent. My lord, on the last occasion, as I recollect, my lord, your lordship desired to know the points on which either sides are relying on, my lord.
Yes.
So, my lord, I have the points in my hand, my lord.
Lordship, I am appearing on behalf of the petitioner, Your Lordship. I am led by Mr. Ajay Chaube in this matter, Your Lordship. He is not available right now, Your Lordship. So I am praying that the matter may be fixed after 25, Your Lordship.
After?
25, Your Lordship.
There is an interim order
No, my lord, no interim order.
as prayed by Learned Counsel for the
September. Item number 61.
Did you file a reply also?
I have filed my reply, madam. Madam, may I place the impugned order? That is that towards the end of your lordship reign. My lord, I feel much tempting to place the interim order, final order of the state tribunal.
Final order.
Final. This is the final order. My lord, briefly speaking, my lord, this is a very sordid saga of a poor tribal boy whose mother, my lord, got an appointment, compassionate appointment. But before joining, my lord, she succumbed in carcinoma. She could not join. And thereafter, my lord, the son applied for. But the son could not be, and it took long 8 years to consider as to whether the compassionate appointment to the son can be given in place of the mother who could not join even after getting the chance of this affair. So that was an application before the learned tribunal. And before the learned tribunal, my lord, the case was filed in 2022. 818 of 2022. Lot of seizure, my lord. The matter is taken up by the single bench. Pursuant to the order contained in the notification number so issued in exercise of the powers conferred under Section 5 within bracket 6 of the Administrative Tribunals Act. On consent of the learned counsels for the contesting parties, the matter is taken up for consideration sitting singly. Sitting singly. Well, on 3 counts, I have challenged this particular order. First of all, that this gentleman sitting singly has no jurisdiction. He is totally, my lord, without any jurisdiction and without any competence. Without any competence to sit upon any judgment of a tribunal sitting singly. Because he is the single man in the state tribunal for long, long years. And he was, my lord, actually a judicial member. But he was acting as a chairman, he was acting as a vice chairman, he was acting as a judicial member, also acting as a tribunal. Totally, he is the single man tribunal who was sitting upon all administrative tribunal matters before the state tribunal. This is completely beyond, my lord, the concept of the Administrative Tribunals Act, different provisions, one. Second, it was beyond, my lord, the division bench judge of this honorable court. A division bench judge of this honorable court. And thirdly, my lord, the Supreme Court, my lord, had lately delivered a judgment that when a tribunal is not actually functioning, it is non-functioning because of various reasons. In that case, it is the 226 court who will take up the whole matter. The judgment of the Supreme Court is also with me. This is one of the things, but the question of a pure and simple legality ground, this gentleman has no jurisdiction. Then my second ground was, Lordship will kindly see, on consent of the learned counsels of the contesting parties. Your Lordship says for the applicant, Mr. G.P. Banerjee, learned advocate. He is giving consent. Who is he? My client has sworn an affidavit to that effect, that he has never executed any wakalatnama on his side, in his favor. He is giving a consent that you take up the matter, decide it finally. What is happening there? He was nobody. And he is giving a consent. On consent, the learned counsel for the contesting parties, the matter is taken up for consideration of sitting singly. That is Mr. G.P. Banerjee, learned advocate for the applicant appearing. In number of cases, your Lordship will kindly find that Mr. G.P. Banerjee, he is appearing for the applicant, and with the consent, the learned tribunal is making orders, final orders. So, this is what it is. The second consideration. That is totally without any authority. That means abrogating the entire procedural, my lord, fairness. The learned tribunal issued around a final order in respect of a compassionate appointment of a tribal boy, my lord, whose mother, she was given a compassionate appointment even after the approval of the Chief Minister of the state and the learned tribunal. My lord, in this fashion, taking a consent order, my lord, dismisses my application, saying that, well, the application has no merit. My lord, now I place my order, the order. From the order itself, my lord, it will be clear as to what it was. Manjura Soren, a constable with Calcutta police, died while in service with Park Street Police Station on 14/7/2011. At the age of 40 years, Arjun Kumar Soren, the applicant, his applicant and son of the deceased employee, was a minor of 12 years at the time when his father died. Fulmoni Soren, the widow and the mother of his applicant, paid for employment under the compassionate ground for herself before the respondent authority on 23/9/2011, followed by similar application furnished by her before the respondent authorities on later dates also. The state government, by a letter dated 17 June 2022, conveyed a message favoring her application, and the administrative officer of the Office of the Commissioner of Police, by its letter dated 23rd June 2022, asked her to appear, not once, more than once, to appear before him. Appear before them on 30th June 20 along with relevant documents, and this time the mother suffering from a serious ailment. What is the serious ailment? The serious ailment, which was a carcinoma, was not in a position to appear before the respondent authorities. Why it is hide and seek? That she was suffering from a carcinoma? It was on record that she was suffering from a carcinoma. On 20th July 2020, she succumbed to her ailments. With the death of his mother so suddenly, the applicant now submitted an application on 4th August praying for an employment for himself. In absence of any response from the state side, the applicant submitted a reminder on 11th August 2022. Such application was considered and regretted and conveyed to the applicant by a memo dated so and so. The impugned reference mentions the ground of such rejection due to the fact that earlier approval was given to appoint Fulmoni Soren. Earlier appointment, rejection due to the fact that approval was given to the appointment of Fulmoni Soren, the mother of who unfortunately died before such appointment was received. But the prayer of the applicant for such employment cannot be considered as a transfer case. From the deceased mother to her son. The relevant provision cited by the respondent authorities is clause 12B of notification 2251 so and so. The cited clause of notification 251 so and so is as an appointment offered made on compassionate ground cannot be transferred to any other person. Your Lordship will kindly see this. To any other person. Or I will make my submission subject to your Lordship's approval on this clause to any other person. Who is any other person? To any other person, and such request shall be rejected. It is indeed very unfortunate for the family that when such appointment was considered favorably for the widow, but it was considered by whom? It was considered by the highest authority, the minister in charge, that is the chief minister herself. And she gave the clearance. The letters are also there. With all documents, it was filed. Fulmoni Soren, she succumbed to her illness, though the applicant applied for himself after the mother death, but his application is barred under section 12B notification so and so. The respondent authorities cannot be said to have taken an incorrect decision. They did not take an incorrect decision. They were right in terms of the scheme as stipulated in so and so. In terms of such notification, the applicant Arjun Kumar Soren was clearly a new applicant and cannot have the benefit of such transfer of appointment. Having examined the records properly and after hearing the submission of the learned counsel, the tribunal does not find any merit in the application of the applicant, and the respondent authorities were correct in taking decisions, and so accordingly this application is disposed of without any passing any orders. So this is the orders. Yes. Now, my lord, I would beseech your lordship to kindly consider the scheme of the compassionate appointment.
There are two things which I would like to see, maybe before or after you make your submissions in your own way. But I will not be able to understand these two documents. One is at P8,
Pardon?
P8, annexure P8 at page 24.
P8.
And the another is at annexure P9, page 25.
Yes,
According to me, these two documents are very relevant.
P8.
P8 and P9.
P8 and P9.
24 and 25.
Well, P8 is, this is the letter of Mamata Banerjee, Chief Minister.
Please be kind to me.
Fulmuni Soren.
Please be kind to me.
Pardon?
Be kind to me.
Yes.
Please be kind to me.
Official translation. Official translation like that.
Oh, official translation.
Please. These two documents I would like to appreciate, therefore I am saying.
Yes.
I would need translation of these two documents. What was the nature of approval? I would like to see word to word. And what was the application made by the son? I would like to see word to
Well,
word.
an informal translation, I can make it.
Yes, yes, that's all.
Yes, yes. No, that is to be done.
Yes.
Because
Just
there
do-
cannot be any formal translation.
No. You make an informal one,
No,
you
your
give him a
lordship,
copy, that's all.
I'm deeply grateful to your lordship.
Yes.
There cannot be any formal translation in this court. No. Because a formal translation has to be authenticated by an officer appointed by this court. During the last 17 years, no such officer has been appointed. Universalization of the judiciary. That is the informal translation. During the last 17 years, no appointment. My lord, even if this is on technicalities, of course, your lordship is correct, my lord. But it is a division bench, my lord. Official translation for one judge, yes. If your lordship so desires, my lord, then in that.
I would like to appreciate the document. Both the documents I would like to appreciate. Therefore, I am saying.
No, it's all right.
In many cases I rely upon and
No, my lord, I don't deserve your lordship's order. I don't. In my humble way, I can give it, my lord.
whenever tomorrow, day after you take.
Tomorrow itself.
All right. Give
Tomorrow itself.
You give him a copy tomorrow. And we'll
Translated copy.
and we will take it up day after. Just give him a copy tomorrow. Have your office serve a copy on him tomorrow.
Day after tomorrow.
We will keep it day after tomorrow, but give him a copy tomorrow.
Oh, yes.
So he gets an opportunity just
Oh,
in
yes.
case there is any error or something, he may be in a
Well,
position.
let it retain the same position and to pay.
All right. The
হাইকোর্ট থেকে জজ নিয়ে আসা হবে, ট্রান্সলেটেড কপি দিতে হবে, কিন্তু that is how a high court is running.
What is he saying?
I'm sorry, my lord, I will do it. I beseech your lordship direction. I will do it, ma'am.
Item number 132.
কি হলো?
My lord, may I please your lordships, my lord?
Who is for the state?
My lord, the last order, my lord, records the learned AG, my lord, is leading, followed by assisted by my lord, Mr. Shopan Banerjee, Mr. Shushmita Shah, and Mr. Shoman Chatterjee, my lord.
There is none to represent the respondents. जो चल रहा था, the one which we were, हाँ,
Item number 9.
there was a query recorded in our order.
Yes, that I have to answer with your losses. The point is that earlier order of the tribunal directed me to consider, even upon consideration of the rules. I submitted my papers, they rejected. That rejection, according to them, rule doesn't permit. That's the point. But the core rule was considered and direction was given to consider in their presence. And they
said
accepted.
the tribunal said that graduate has to be considered.
Yes. Even then, they said rule doesn't permit, rejected. One judgment commonly, my lord, everybody comes to my mind who are regularly practicing before the court, just judgment of Parihar. The contempt, my lord, the court, this has to be, Supreme Court says, no, you have to question that order. In the contempt jurisdiction, we cannot go into the correctness. That's, my lord, if necessary, I will cite that judgment. But before that, my lord, we are 45. And this judgment was followed by our High Court, repeated, my lord, number of occasions. This is a judgment of the Honorable Division Bench of the Honorable Patna High Court. And this was followed by this Honorable Court at least twice, if I am not wrong. That second writ petition is maintained. My lord, this is reported in 1982, SCC Online, Patna 21, corresponding AIR 1983, Patna page 8. My lord, I will be relying upon paragraphs 2, 5, 7, and 8. Now, should I read out to your lordship?
Paragraph, sorry,
2, 5, 7, and 8.
just give us a minute. Just give us a minute.
Yes.
Now, paragraph 2, your officer. Now, kindly come to paragraph, state by paragraph 7. 7 and 8, I will be placing. Even if the meeting was held on 30th December 1980, as alleged by the petitioner, it was after the order of this court on 23rd December 1980, which runs as follows. Put up for admission on the 8th January 1981, as prayed for, on behalf of the state to enable the learned council to obtain instructions. In the meantime, no election should be held. Our order is explicit and clear, and we actually mean that no meeting should be held because of the learned council appearing for the state wanted to take instructions in the matter. The order was passed after we were prima facie satisfied that there were good grounds for staying the meeting. Mr. Singh has contended that it was a mere wish and not a command. It is difficult to accept this contention if we really meant to leave the matter to the discretion of the parties concerned. Then we would have refrained from saying anything regarding the holding of the meeting. No doubt, CJWC of 1980, in which the stay order was passed, was withdrawn. That, in my opinion, will not make any difference so far as the impact of our order is concerned. The petition was pending on the day when the meeting was held. Reliance has also been placed in the case of Commissioner of Income Tax versus B. N. Bhattacharya, where an appeal filed by the revenue was withdrawn on certain conditions given by the assessee. And it was held that even if proceeding was withdrawn, settlement could be arrived at between the parties under the provisions of the IT Act. I fail to understand how this decision helped the petitioner and is not at all relevant for the point in issue. Withdrawal of a case at a later stage, in my opinion, will not obliterate the interim order passed earlier. It has been rightly contended on behalf of the learned Advocate General and Sri Indu Shekhar Prasad Sinha that the meeting held after the stay order passed by this court must be held to be non-est. In the case of Murlaj versus Murti Raghunath Maharaj, a distinction between injunction and stay order has been very clearly explained. In the matter of stay, it will be effected from the time it is known to persons concerned. But any action taken in ignorance of such order can be rectified if it has caused injustice to any party. By setting aside the election held on 30th December 1980, we will be doing justice between the parties, even if it may be assumed for a moment that this order was not communicated to the person concerned. In the case of such and such year 1974 Supreme Court, page 1471, an order of externment was passed and the case was lost, in which the accused was acquitted by the trial court and the state preferred an appeal which was pending. In the meantime, the order of externment was quashed by the High Court under Article 226 of the Constitution of India pending the criminal. A point was raised in appeal against the acquittal, and that since the proceeding had been quashed and had become void ab initio, there was no quit order in law and there was no offense. It was observed that an order which is void may be directly or collaterally challenged in legal proceedings. An order is null and void if the statute clothing the administrative tribunal with power conditions it with the obligation to hear expressly or by implication. Therefore, if a competent court holds the order to be valid or sets it aside, it operates from the nativity, thus the impugned act or order was never valid. As stated in American Jurisprudence, volume such and such, page 504, as act done in violation of injunction, even nullified, is to be deemed ineffectual and unavailable as to the purpose intended, as though it had not been done. It may also be mentioned that in the counter affidavit filed by the respondent number 7, it has been stated that the information regarding the order of stay passed by this court was given to the persons concerned by the executive officers. And in this connection, Annexure D has been relied upon, which is dated 29 December 1980. On the face of this document, it is very difficult to accept that the meeting was held on 30th December 1980 in complete ignorance of the stay passed by this court. Be that as it may, any meeting held after the order passed by us has to be completely ignored, and the case law referred to above fully support the respondents. Paragraph 8. Now I take up the submissions of Mrs. Singh that even if there was a violation of the order, action has to be taken under the Contempt of Courts Act 1978, which is a self-contained act, and procedure has been laid down for violation of such orders which may amount to civil or criminal conduct. The inherent power of the High Court, the argument continues, puts a limit on the powers by requiring a trial of the issue and enjoins that no sentence can be imposed unless the court is satisfied that the contempt is such a nature that it substantially interferes and tends substantially to interfere with the due course of justice. And in this connection, reliance has been placed on some decisions, which I will discuss later. But at the very outset, I must say the argument is wholly misconceived. The question of committal or non-committal under the Contempt of Courts Act is one of the discretion of the court and can be exercised when this court is fully satisfied that there has been a deliberate attempt to flout the order of this court. These will depend on the facts of each case, the nature of the order, the act complained of. But without initiating a proceeding for contempt, this court can quash an order or proceeding done in disregard of such orders, which may also tantamount to contempt. It is very difficult to accept this extreme proposition that the acts done in defiance of the court's order can only be dealt with under the Contempt of Courts Act, where a complete machinery is provided for and in no other manner. The Act does not put any bar. By acting this proposition, this court will have to completely ignore the illegal acts of the subordinate authorities, and I may fashion to add that this would lead to dangerous results. This court, when confronted with such a situation, has to exercise its power conferred under the Constitution and pass necessary orders to undo the wrong and to do justice between the parties. In the case of P.A. Thomas versus Company Mold versus Queen's Bench, an order of injunction was passed. Defendants restrained from divulging confidential informations. It was argued that in order to have a clear direction by the court, the plaintiff must allege in clear terms what he alleged to be confidential, which he sought to be protected. And if it was done, even if there was a violation, plaintiff could not complain because of the vagueness created by him. But in the instant case, nothing was suppressed before this court when the interim order was passed by this court, and therefore that decision doesn't help the petitioners. In the case of Delhi versus London Bank Limited, ILR, Indian law reports, there was a money decree and the certain properties were attached, and the bank, by virtue of another decree, got the properties attached and sold. The decree holder objected that the bank had no claim over the properties which were attached by him, and that was allowed. A suit was brought by the bank against one Ram Narayan, the decree holder, in which it was held that the trial court that after injunction no transfer of property could be made, and therefore the bank had no interest. The appeal was allowed, and the matter went to the High Court, where it was held that the subsequent mortgage and auction thereto was illegal and void, and for the breach of the injunction if any separate procedure had been laid down. In this case, for the breach of the order of this court, proceedings can be taken under the contempt courts also. And this court, in exercise of its power, is competent to set aside anything done in violation of the order. Kusum Devi versus Malavati Bawa, AIR 1961 Orissa, was a case relating to temporary injunction, where property was sold and it was held that the sale was nullity and violation of the order can be dealt with under Order 39, Rule 2, Subclause 3. That was a case under the Civil Procedure Code where a complete procedure has to be followed, and that cannot be applied to cases filed under writ jurisdiction. In a full bench case of the Orissa, B.K. Mishra versus Chief Justice Orissa High Court, AIR 1974 Orissa, page 1, a departmental proceedings was started against a public servant, against whom some charges were pending before the court. It was argued that the departmental proceedings amounted to contempt of court. The argument was repelled by his lordship, and it was held that the institution and constitution of the disciplinary proceedings in good faith did not obstruct or interfere with the courts of justice in pending court proceedings. The meeting was held on 30th of December 1980, cannot be said to be held in good faith, and the members ignored the stay order passed by the court. There may be a good defense in case contempt proceedings is started, but action taken by them in spite of the stay order, as I have said earlier, cannot be ignored or overlooked. This argument on Mr. Singh on this point has to be rejected. Now, this is exactly point comes up before this honorable court. Malad, even your lordships can issue suo motu contempt now. Why have you violated it? Malad, that doesn't restrict me to come up before your lordships and to show that has to be done. Malad, this order.
You are relying on this judgment only.
No, Malad, I tell your lordships, this judgment has been followed, Malad, very succinctly by our High Court in sitting in the single bench. Your lordships, kindly have a look at this. Very short order.
We are bound by which judgment?
Malad, obviously division bench, but Malad,
division bench of another court.
Malad, I tell you, division, that's your lordships, Malad, persuasive value. And I show your judgment of the Honorable Supreme Court, impliedly that is found. The judgment of the Patna High Court holds the field.
Where is that? Show us.
That's also, Malad, just Malad, let us place it, your lordships.
Setting aside an order which is in contravention is another thing. Reissuing the same direction in a successive writ petition,
Malad,
or declaring the same thing again in a successive writ petition. That was the query of the court.
That's that I get. Malad.
Yes.
Ultimately, I will be answering to that.
Yes.
The petitioner is a home guard. He was attached to Mandir Bazar police station. The officer in charge of the police station directed the petitioner to accompany him to Bhavanipur Police Hospital for the treatment. Surprisingly, the superintendent of police on such and such date dismissed the home guard concerned for complying with the direction of his superior. The home guard concerned challenged the order of termination before this court, which was registered. On November such and such, the Honorable Court allowed the writ application, and consequently the said rule was made absolute. The order of discharge was set aside, and the respondents were directed to reinstate the petitioner in service within a period of 30 days from the date of communication of the said order, with all back wages from the October 30th, 1978, as might be admissible to him under the relevant rules and in accordance with law. It was further directed that the back wages have to be made to the petitioner within 60 days from the date of his reinstatement. The writ application is moved to or in order to implement the said order, dated November 2, 1978 of this court, inasmuch as admittedly the writ petitioner was not reinstated, nor his arrears have been released in terms of the said order dated such and such. No affidavit in opposition has been filed by the respondent, even tried to offer any defense. The respondent had full knowledge of the order and they have no defense or excuse for non-compliance of the order. However, it is suggested that the present writ application is not maintainable for securing compliance of the said order. However, it is suggested that the present writ is not maintainable for securing compliance of the earlier order passed by this court, and the writ petitioner should have moved an application for contempt. A division bench of the Patna High Court in Naul Kishore Singh and such held. All of then your losses, this paragraph 8 portion has been quoted. Now paragraph 6, because I have already placed it, that's why I'm not avoiding it, your losses. It is therefore settled law that the second writ application is maintainable for implementation of an earlier object. This court must issue appropriate directions for proper implementation of the previous directions. Where there has been an order, the order must be complied with. An act done in willful disobedience of a court's order is not only contempt, but also an The language used in Article 226 of the Constitution of India is couched in comprehensive phraseology. And the said article recognizes a very wide power on the High Courts to remedy injustice wherever it is found. But this is exactly where I am here now. Now, Malad, I could have filed a contempt application for that, for securing compliance of that order. But here an order has been passed by them. That, Malad, obviously in defiance of the court's order. Now, Malad, another proposition side by side, any act in defiance of the court's order is a nullity. So I can come up before the lawsuit for declaration that order, considered order is bad. Kindly reimpose the first order and direct to act accordingly.
That is all right. What you are saying, we have understood. What we asked you is when a declaration has been made regarding a particular thing and a specific direction has been issued, if that is not complied with and you invoke the writ jurisdiction again, you say it is an illegal act.
Complied with, they have according to them, they have passed an order in terms of that.
We don't.
But that's contrary to
That's not the point. The point is the High Court gave a specific declaration
no,
that the
tribunal.
graduate apprentice have to be considered.
No, that's the direction of tribunal, not the
The tribunal, correct. The tribunal gave a specific direction that the graduate apprentice has to be considered, although preference can be given to the
That's it.
matric apprentices. They have violated this. So you say it is in violation of the court's order.
I will not put it on so pardon me. I will say they considered, but their result of consideration amounts to defiance.
What was left to be considered?
That's the point you lost.
So precisely.
Precisely, they had no other option.
They had no option. They had not. There was nothing to consider.
No, I tell you, loss. They have. Suppose, they have considered. There are two things, situation may arise. One thing, they cannot debar me from consideration only on the ground of graduate.
Correct.
But they can debar me from consideration.
But that's not. That's a hypothetical situation. That is not there. That is not there.
Suppose your losses. That's the point.
Here, what they are saying is because you are a graduate, you will not be considered. So it is directly affront to the declaration and direction given by this court. And therefore, you say in the circumstance, writ court is not remediless, writ court is not powerless. It is void ab initio. It has to be set aside. Let us say we agree, we don't know, and we do it. You come back here with a third writ petition. Maybe, because if you are not getting the order of the court enforced after obtaining an order, and you keep running in circles back to the same court, then you are only emboldening the authorities to continue with this.
My submission that situation in the second writ petition, the order, whatever may be the nature of it, that should be quashed, and the directions should be passed in the light of the earlier direction of the tribunal to immediately consider, without considering the graduate one.
Precisely, and if they do the same thing again, then
then your losses, not court is not remediless. I will say, they purge the contempt comes up.
So therefore, after 2 times contempt has to be invoked.
Not the 2 times your losses. Suppose I had come up with the.
This aspect which we are raising is not considered in both these judgments.
But these judgments
are slightly different. Here there is a specific direction, a clear declaration that is not complied.
Then again,
this judgment, of course, is on the similar lines, but this is of an honorable single judge. The other judgment is slightly different because there are 2 things. One is that there was an issue that it communicated, not communicated. The other thing is that the writ was withdrawn. The writ was withdrawn. And it was an interim order. So there was no question of the writ court having given any relief or any mandate or any mandatory direction in the final terms that which was required to be complied by invoking the contempt judge. That was an interim order case.
No, I tell you,
here it can be said to be similar, but
what happened, according to my understanding, interim order was passed, then writ petition withdrawn or dismissed. But the interim order, in violation of the interim order, they acted. The question came up ultimately. Even the writ petition didn't survive. You violated the court's order, so you could be held up for contempt. And that's the one of the submission. Writ court said no.
Our understanding is slightly different.
The writ court
our understanding is slightly different. There the writ court said that the contempt was committed during pendency of the writ and before it was withdrawn. Please read again. Yes. How can an interim order continue beyond the writ? once a writ is withdrawn. It cannot. So please read again. There the contempt was committed while the writ was still on the records. It has not been withdrawn.
Now, your losses will find. Yes, paragraph 2 probably your losses will give.
No, come to paragraph 7, the second page, paragraph 7. We have refrained from saying anything. Read from there. No doubt CWJC, yes. Read.
No doubt.
Yes.
In which the stay order was passed was withdrawn.
Please proceed.
In my opinion, it will not make any difference so far the impact of our order is concerned. The petition was pending on the day when the meeting was held.
Exactly. So in contravention of the court's order, during pendency of the writ petition, they had held a meeting for the election which the High Court had stayed. It cannot be that even if it is disposed, that will be stretching it slightly a bit too far. Once a writ petition is withdrawn, nothing will survive. An interim order will definitely not survive. It cannot travel beyond the final.
Even if your losses.
No, not even if. That's in so many terms it says that petition was pending on the day when the meeting was held. Therefore, the court has said that you can't say there is no contempt. You could have said this if you had done this after withdrawal. Then, of course, there would be no contempt.
Now, this malad, if your losses, I don't know malad, it's omitted or the other thing. Paragraph 8 malad.
No, this is a record of fact. This is whether the question of obiter. This is recording the facts of this case. You are referring to 8 different paragraphs.
Now, kindly consider. The question of after paragraph 8, may I just say now take up the submission of Mr. Singh. Even if there was a violation of the order, action has to be taken under the Contempt of Courts Act, which is a self-contempt act, and procedure has been laid down for violation of such orders, which may amount to civil or criminal. The inherent power of the High Court, the argument continues, puts a limit on the powers by requiring a trial of the issue and enjoins that no sentence can be imposed unless the court is satisfied that the contempt is of such a nature that it substantially interferes or taints substantially to interfere with the due course of justice. And in this connection, reliance has been placed on some decisions, which I will discuss later. But at the very outset, I must say the argument is wholly misconceived. The question of committal or non-committal under the Contempt of Courts Act is one of the discretion of the court.
Yes, you have already read this. Yes, you have read.
Often after consideration.
And the case which was being considered by the High Court was a case arising out of an interim orders violation. The court found that it had been violated. The court at the same time was faced with the fact that the writ was withdrawn. There was no final order in the earlier writ proceedings. In this judgment that you are relying upon, there was no final order in a writ proceedings. As in your case, there is a final order by the tribunal. The tribunal has the jurisdiction to proceed for contempt and for implementation of its orders. You say, no, I will approach again. You give another direction. So we say, if they don't comply, what will you do? A third direction.
No, there is no question of third direction.
There may be, we don't know. They may be emboldened by this action that if they will go for the tribunal,
they have to purge the contempt.
Then why not now?
No,
Why after second time? That is the point.
I tell you, losses, why not now? Since there is a consideration order.
Oh, there is no consideration.
Declaration of the ultimate order for consideration.
Anyway.
That's the point.
All right. So that is your submission.
And other judgments. Here also, my lord, the division bench judgment of the Honorable Patna High Court was followed.
All judgments you are getting of other high courts.
No, of our high court.
All right.
Consistently followed.
So that judgment was followed here also. The same judgment was followed here also.
Exactly. Paragraph 11 on. I'm not taking the loss of the order. Well, the father of the writ petitioner who was appointed as primary teacher made an application for permission to retire and to appointment the writ petitioner compassionate ground. On the basis of the said application, inquiry committee was constituted and they gave a report to the financial condition of the family of the said teacher and recommended the constitution of the medical board. No steps thereafter taken, and the writ petition was taken out by the father of the petitioner being such and such. The said writ petition was disposed of directing the chief medical officer to constitute the board and to keep the report as to the medical condition of the said teacher. Though there was a specific direction, but no step was taken thereafter. In the meantime, the father of the petitioner died. After the death of the respondent number 2, rejected the second application, which was channeled in the another writ petition, and the said decision was quashed to the direction to give appointment to the writ petitioner on complying with the requisition made in the memo dated 12th October 2004. The only consideration left after the subsequent order dated 31st March 2008 is if on verification of the documents required to be submitted in terms of the memo dated 12th October 2004, the same is not found to be genuine and sufficient, the application could have been rejected. Otherwise, the earlier order passed by this court was clear and explicit, and that if on verification nothing was found adverse to the writ petitioner, an order of appointment should be passed. It would be profitable to mention the said memo, which are as follows. Then, paragraph 15. There is no doubt that pursuant to such memo, documents indicated therein was duly submitted, whereupon it appears that monthly income of the widow is of rupees 2,200, and that the daughter-in-law is rupees 300, apart from the several certificates issued by the local Gram Panchayat, and no objection was given by the elder brother. In spite of such compliance, as well as the order dated such and such passed in an earlier writ petition, no step has been taken by the respondent authorities as yet. Since no affidavit opposition used and there is no document before the court whereupon can be gathered, the documents as requisition in memo dated 2004 is not genuine and sufficient for the purpose of appointing the petitioner on compassionate ground. Though the court should not pass an order of appointment which is in the domain of the appointing authority, but this is an exceptional case where the court should exercise its power, directing the respondent authorities to give an appointment to the writ petition. Before taking up, as indicated above, other legal points urged by the learned advocate appearing for the respondent number 4 as to maintainability of the writ petition are to be dealt with. The point taken by Mr. Mitto that a subsequent writ application for enforcement of an order passed in an earlier writ petition is not tenable in view of the judgment delivered in case of Vivekananda Mondal Supra, where the learned single judge, while confronted with similar point, was pleased to observe this. Then, Malak, the single bench judgment of our High Court was quoted. Then, it is therefore settled law that the second writ application is maintainable for implementation of an earlier order of the This court must issue proper direction for proper implementation of the previous directions. Where there has been an order, the order must be complied with. An act done in willful disobedience of court order is not only contempt, but also an illegal and invalid act. The language used in Article 227 is a comprehensive phraseology, and that the article recognizes a very wide power on the High Courts to remedy justice wherever it is found. The support can also be made from the judgment of the Honorable. This judgment I am supposed to place with your lordships, the 2007-7, where we are of the considered opinion that once a direction is issued by a competent court, it has to be obeyed and implemented without any reservation. If an order passed by a court of law is not complied with or is ignored, there will be an end of the rule of law. If a party against whom such order is made has grievance, the only remedy available of him is to challenge the order by taking appropriate proceedings known to law. But it cannot be made ineffective by not complying with the directions on a specious plea that no such direction could have been issued by the court. In our judgment, upholding such argument would result in chaos and confusion and would seriously affect the impaired administration of justice. The argument of the board therefore has no force and must be rejected. The order passed in a proceeding against the parties therefore binding on the parties. If any of them is aggrieved by such order, the remedy is to challenge the said order in appeal. Then you lost, this is another proposition. Tribunal order was not questioned. Paragraph 20. Thus, an order which was passed in an earlier institution, which was assailed by the respondent, attains finality on rejection of an application for condonation. Then, my lord, the other parts, then this court directed, we allowed and to pass order of approval of appointment of the petitioner as a consequence. Now, my submission before lawsuits, now he has to be said that if I have otherwise all conditions fulfilled, I should be appointed. Other than the ground of graduate. If I fulfill the other conditions, I should be directed to be appointed. Cardiologist's father in the meantime died. There was no question of medical report further. So consequential relief was appointment of the son. So here your losses kindly ignored their observations in the considered order that I am graduate. The rest, my lord, I have to be considered in the point. Now you'll also find that 2007, one of the paragraphs was quoted by the letter. Because sometimes some of the paragraphs are so pervading your losses that it's depend upon our perception. So read court is not so wide jurisdiction. For ends of justice, court can do different things.
No, that is a very, very, very settled proposition. What we are on is that can the authorities be permitted to do like this?
That's why I'm citing.
If you do, if this is a resort taken by the litigants, then it is very good for them. They will keep passing such orders. You keep going to the court.
That's why your losses has to.
Then there will be no finality.
Your losses has to protect.
So this time proper order has to be passed. Last time improper.
No, but not the proper. I am saying.
That is, you have laid stress while reading that the proper direction has to be issued. What do you mean proper direction?
Says now this is to be done. The consideration was rejection.
Maybe in a subsequent time from now, the next bench may feel that our order is not proper. More proper order is required.
No, that's one of they have to challenge. Authorities have to question it.
Let us see. Let us see. All these cases. In this case also, there was a subsequent development which changed everything. The person who had come to the writ court, he was no more.
But the implementation of the order.
We don't know, but we are telling you these are very vital factors. And that is why taking note of such a exceptional circumstance, His Lordship has said that it is a very exceptional circumstance and therefore we are doing. As a routine, can a litigant keep approaching the writ court for the same direction?
No, not the same direction, your losses.
Exactly same direction. Please see.
Ultimate prayer appointment.
Please see your relief is one and the same.
But my first application before the tribunal was that I should be appointed. I should be considered.
Where is the read your prayer in the first application? And please read the second application prayer.
No, first the appointment. First application. Copy total quote করা আছে. Let's see. Just a minute. Just a minute. দাঁড়া না, অধৈর্য হচ্ছিস কেন?
Come to page 161. The prayer is noted in paragraph 5.
way has been preferred by the arguments to the following reading. Speaking order dated issued by the principal chief secretary, CLW cannot be sustained in the eye of law, therefore state may be quashed. Well, I tell you, Lordship, this order was regard to part-time recruitment. That was another. Direction such and such is not applicable in respect of the applicants in the said circular was issued after commencement of training. Then an order to issue respect to engage the applicants in group C, such and such. Then leave may be granted to file way jointly under such and such.
Now come to the relief, paragraph 10 on the next page.
The minimum requirement is that of matriculation and course completed act apprentice certificate, and that course completed act applicant may get preference over the others in the selection process. The applicants that graduate are well within the right to participate in the selection process.
Yes.
And being considered.
Therefore,
Such who have applied
be allowed
to participate.
Yes.
Participate in the exam.
Now let us see your prayer in the current way.
Page 7.
Page 70.
At the bottom portion. Okay. An order causing the decision to reject the candidature of the applicant. They have rejected my candidate. An order setting aside the decision not to consider post-completed act apprentice from railway organization. And then order interpreting the contents also, and order holding such and such, order showing to call the applicant to appear in the medical and thereafter to grant him appointment. So all that I am praying for, you will see 5. Virtually, Malad, I tell you what happened in the first application when I was Malad. Initially, I was recruited for temporary purpose. Under the same, there was then change of rules, all that. Then the question come.
You were recruited after the tribunal's order.
No, before the tribunal's.
That
temporary, all that. But that was Malad discontinued. So we impugned that order before the tribunal. With the following. When the question came up that in the selection process, graduate apprentice cannot be considered. The court went in, the tribunal went into the point. Then held, if you consider matriculate and they are being graduate, have complied the same course, you will not consider them. There is no logic. This is not acceptable. So this question came up.
There is no other question today.
Now, today your losses, Malad. Suppose I tell you losses, Malad. If I Malad, this is my submission.
No, we are trying to understand. There is no other question today.
That's the
question remains one and the same.
Consequence.
The question which has been answered is being raised again.
Malad, then your losses will the consequential relief to be granted in the second application. I direct them to appoint. That's my prayer 5.
Therefore, we are saying for implementation of court's order, whether this is to be done.
This has to be compliance, because they can't resist my application or participation on the point where the court has already found to be good. So that's
the judgment you have relied upon, we have seen that.
That's the point, your loss.
Apart from 226, there is 215 also in the Constitution of India.
That's your loss. That's your loss.
Whether
we have in this side.
No, we are, see, it's not a case of this case. We are thinking in terms of administration of justice. Whether you are giving the authority an opportunity to act with impunity, go and get another order. Go and get a third order. What is crossing our mind is not something about this, about this case only.
I think
the moment we start doing this,
I think the respondent would be educated by this. If you go like this, we will be doing.
Are we here to educate? Once we have passed an order, they have to implement.
Ultimately, this is dispensation of justice by your losses. So justice demands your losses.
Then tomorrow it will be a plea in any case. That why
a person's a citizen, he is asking for something in accordance to law. That's your loss. Malad, your losses according to me, your losses in 226 we are according to law. That your losses kindly consider. Then your losses will find the judgment of 2007 volume 7 SCC. Kindly take note of your losses this judgment. 2007 volume 7 SCC page 689 paragraph 2 to 6 13 14 16.
You have given us a copy.
Please, I have just sent it up. I mean, Joseph, the copy.
7-7.
7. There are 2 copies I give.
Yes.
Now, kindly take note of I am relying upon paragraphs 2 to 6, 13, 14, 16, and 25 to 31. Now, the present appeal is filed by the Commissioner, Karnataka, Housing Board against judgment dated passed by the Honorable Division Bench of the High Court of Karnataka. By the order, the Division Bench set aside the order dated passed by a single judge of that court in writ petition number such and such. The Division Bench held that the dismissal of the claim of the respondent employee, writ petitioner, by the learned single judge on the ground that contempt petitions filed by him were dismissed was not legal and in consonance with law. The Division Bench hence directed the Appellate Board to implement the direction issued by the learned single judge in writ petition number such and such, decided on 27th October 97 in letter and spirit, and disburse all consequential benefits to which the writ petitioner was held entitled. The facts of the case that the present respondent herein joined service in Karnataka Housing Board in the year 1972. He was appointed as second division assistant and was promoted as first division assistant on 1972. In 1974, a seniority list of the division bench first division assistant was published. The writ petitioner challenged the said seniority list by approaching the High Court under Article 226 of the Constitution. Writ petition was allowed on 1997 by a single judge of the High Court of Karnataka. The court directed the board to reassign seniority of the writ petitioner by placing him above respondent numbers 2 to 34 and to grant other consequential benefits. It appears from the record that the writ appeal filed by the state against the order passed by the learned single judge was dismissed. Even special leave petition was dismissed by this court. The order passed by the learned single judge thus became final. It is the case of the court that the order passed by the court was implemented, and the writ petitioner was reassigned seniority above the respondent numbers 2 to 34 as per the direction of the court, and also granted consequential benefits. The grievance of the writ petitioner, however, was that he was granted consequence benefit as awarded by him to him by the learned single judge and confirmed even by this court. The writ petitioner retired from service in the year 1998. Since consequential benefits were not extended to him, the writ petitioner filed contempt petition which was dismissed. Similarly, another contempt petition was also dismissed. He thereafter filed a substantive petition, being such and such, contending that an order was passed in the writ petition filed by him, wherein direction was issued to reassign him seniority and consequential benefits, arrears of salary to which he was entitled was not paid to him. The said action was clearly illegal, unlawful, and not sustainable at law. A prayer was therefore made that the board may be directed to extend monetary benefits as per the judgment rendered in earlier litigation. The learned single judge, as observed above, dismissed the petition, observing the division bench disposed of contempt petitions, observing that the board had complied with the directions issued by the learned single judge in 1992. According to the learned single judge, if it were so, the writ petitioner could not contend that it was not entitled to monetary benefit. He was entitled to monetary benefits from the date he was denied seniority in the final gradation list of the first division assistants prepared and published by the board. The petition was therefore dismissed. Intra-court appeal, however, was allowed by the division. The board has challenged the order passed by the Honorable Division Bench of the High Court, Karnataka, in this court by filing this appeal. I'm skipping over then. I'm taking to paragraph 13 to your losses. Straight away बोलें.
Yes,
Here your losses see, the contempt petition was also dismissed.
yes, because there the court directed to give consequential
Benefits.
The authorities said we have given consequential. He said no, consequential does not mean after retirement. Consequential also includes prior to retirement. That was an issue to be decided in the subsequent case. Because the earlier court did not direct in specific terms that for the period of service also it had to be. It said consequential orders
consequential.
And
after-
consequential relief, they understood to mean from the date of retirement because he had never worked on the higher or senior post. Subsequently, the court has said that yes, he will get for that also. So there was no specific clear direction that he must be given the benefits for the period prior to retirement.
Here your loss is direction to participate. I was
Here
allowed
the
to
specific
participate immediately.
direction is that you cannot be non-suited for being a graduate apprentice.
Well, they said rejected according to rules.
No, come to para 10. What the court directed, the applicant, graduate, apprentice are well within the right to participate. This is a specific direction. On the ground of being graduate, you cannot be rejected.
Well, this is your lordship's declaration of my right that I have a right to participate and consider.
As a graduate, you have to be considered.
Well, this is your lordship's well within the right to participate.
Yes.
My right.
Yes.
I participated, they rejected.
Earlier also the same thing was being done, that because you are graduate, you cannot participate.
No, that was not done.
Let us see.
That's your lordship. That's not the.
That is why you had come to this court. You were not being considered because they were only considering matriculate apprentice.
They were not allowing this graduate.
Correct.
According-
Correct. Now the court said no, you have to be considered.
But this is, my lord, during the petition, during the pendency of the original application. When I came up before the tribunal, that situation didn't arise.
Whatever it is, the final order is what is to be seen. The final order gives a declaration that graduate apprentice are entitled to be considered.
Now they have considered and rejected.
On what ground?
But that's your lordship's kind of look at this.
On what ground? That you are a graduate. Only ground is that because you are a graduate. So therefore, again, we have to declare that on the ground of graduate, he has to be considered.
That's not your lordship. I am not requiring that.
You are. Otherwise, how it can be?
But that's other than
Cannot be.
I'm compliant. I'm otherwise.
It cannot be. It cannot be. That order will have to be set aside and we'll have to repeat the same direction.
No, your lordship is not. I don't not because that's non-est. Your lordship has to declare that that order is non-est and therefore we appoint you.
How can we?
Because I have not been said to be any.
How can we direct? Even after participation, you may not be eligible for appointment.
Well, that's your lordship. That question now cannot arise now.
Why it cannot
Because
arise?
They have not said it.
Because the earlier order of the court says, tribunal says that preference has to be given to matriculate.
But that they have given.
We don't know.
But that's on record.
That you can say.
That-
We will not take it. How we can give a direction to appoint? We don't know ultimately, even after being eligible, you may not succeed. Right? The issue is whether as a graduate you are eligible or not. As a graduate, the tribunal held you are eligible. They say no. You say again, now you direct them to appoint. Your eligibility only could be declared, and that has been.
Now your lordship will find the order passed.
See, last time, see what the court has said. Because he can be considered. They say no, your graduate is not considered. They say no. So how can we say appoint him? They considered him. Their consideration does not lead to a still conclusion that he will always be appointed. Even if they accept the graduates, or graduate will not be appointed. Some will not be. Some will be appointed. How you can say to appoint? How can we say to appoint? That cloud is already.
Really? No. It is. Now, my lord, kindly see the rejection order. That's at page 251. My lord, Annexure PA. Document verification or that kind of pending due to lacuna of documents for non-completion of medical examination biometric mismatch. These Gimble have to submit their required documents or complete their medical examination and or appear for the check of their biometric credentials. However, even after last for final call was given to these candidates, below mentioned candidates have failed to submit or complete their medical. Thus, the candidature of these candidates is being cancelled with immediate effect. No further queries will be entertained by RRC in this regard. Then my name will appear at page 253 in this rejection order. Top, serial number 46, Moina Goswami, rejected in terms of clause 12.1 and note below clause 6.0 of notification. This is not even speaking order also. This order I question. (12.1) your losses will be getting at page 134 page and note below clause 6.
Zero, same thing, graduate apprentice will not be accepted.
But that's not, order doesn't say.
Now oh, it surely does. Don't say it doesn't say.
Notification.
Rejected in terms of clause 12.1 and note below clause 6. What is the note below clause 6? Read. Come to page 126. Yes, graduate act apprentice will not be accepted. That is the note. Same thing. Now 134, let us see what you are showing. Nothing, no difference. This is exactly the same thing. Graduate will not be accepted. Same. Exactly as if it is sitting in appeal over the order passed by the tribunal. Tribunal says you have to entertain graduate. They say no, graduate act will not be accepted.
So, my lord, according to me, this, my lord, I just tell your lordships, this is not the, my lord, this is implementation of the earlier order in this. There.
Yes. What interpretation? Already tribunal has said that it has to be considered. Where is the question of interpretation now?
My lord, prayer has been made several.
You see your prayer. Yes, see prayer 2, 3. Read prayer 2 and 3.
But I'm not pressing 2 and 3. I'm pressing the whichever, my lord, I have prayed 100 prayers. I'm pressing one of the prayers.
Prayer 5.
Prayer 5.
How can we direct for your appointment?
Call the applicant. I summarize my submissions. On graduate, they cannot reject me. So what will be the rest? They will call me, examine me, and proceed in accordance with law. That's the point I'm asking for. And ordered, I have made several prayers.
Where are the prayers?
There's page 75. An order directing to call the applicant to appear in the medical examination and thereafter to grant him appointment. I have to follow the rest of the except graduate.
So they should deem that you have qualified the CBT.
CB, I tell you, lordships.
It should be considered that you have already
I
qualified the
should be
CBT.
I should be considered. And,
How can such a direction be given? That you call him for physical verification examination.
that's the only point.
Unless you qualify CBT, that is a requirement in the recruitment process at 135.
I come.
How can you?
I come to it. 135. But your lordships is referring to recruitment process. Computer-based test, physical efficiency test, and document verification and medical examination. So they have to take all these examinations. They cannot frustrate the order. When any interpretation goes to the extent of frustrating the order, that should be avoided.
We don't know what you are interested in.
But that's your lordship, that this
Whether you are interested that the order should be complied or not, we don't know for sure. As the applicants, the way he has approached, we are not very sure.
Therefore, my humble submission, your lordships, that they have to comply with the rest, and if I am found otherwise.
Your prayer 5, can it be allowed? Please read prayer 5.
An order directing the respondent number 4 to call the applicant to appear in the medical exam.
How it can be? How can you appear in medical
But
exam?
your lordship has to say that in accordance with the rest of the rules.
Oh,
that
we have.
can be done in the writ court, your lordship.
So everything we have to do to somehow give you an order in a second writ petition.
Somehow is not your lordship I am asking for. The only ask, they say that the graduation.
Yes, all right. So we have understood what you said.
And then your lordship, that's one of the factual what remains. But if your lordships kindly consider your lordships the judgment I am now reading your lordships. Earlier orders that reassigned above 20 to 22 to 24 and give consequentials. So consequential always after reassignment. So it's also clear. Somebody says it's not clear, that's his defense. The ultimately court says this is clear.
Sir, the contempt court held that there was no defiance.
That's my point.
Correct. There was the contempt court already held that there is no contempt. Therefore, in that circumstance, of course, it will not be a successive writ petition for the same. It will become a different thing.
I tell you, losses, if I have
it cannot be.
I read correctly, if I write it correctly, contempt is the discretion of the court.
We are not on that.
That's why
those are settled things. We are not on any of these issues. Whether under 226 we can exercise jurisdiction or not. How 225 is to. That's not the point. The point is when a court makes a declaration, it should be the endeavor of the court as well as the party that there should be some finality to a decision of the court.
That's the point.
Correct. That's the point. That's the point.
Now you're lost.
Now, whether it is to attain a finality or remain in a process to be re-agitated for the same.
Not re-agitated. This is the second one.
That you have submitted. That will consider.
If my perception of all the judgments right from Patna High Court Division Bench, just because somebody didn't initiate contempt proceedings by filing an application, that doesn't mean the order should be frustrated.
Correct. That you have said. That is very well. You have already said.
That has to be. So what are the options to be, your lordships? Because that contempt is the discretion of the court.
The issue that we are raising, you have not addressed.
Well, that's
whether a court's order has to, any finality has to be attached to a declaration, decision of the court or not.
Well, that's finally to be attached. Now, if any order I say today before your lordship that one order is passed contrary to the finality order attached to the order of the court, then that order automatically goes.
Very well.
Your lordship has to just declare that order is a nullity and then consequential will follow. That's my submission before your lordships. Your lordships, they have rejected. So your lordship has to declare that has to go.
Again,
And then consequential you gave him without decoding that.
Properly this time.
Your lawsuits will participate to consider. Consequential, all that, your lawsuits, the earlier order didn't say that. It's a declaration.
The earlier order said
I'm
that as a graduate you have to be considered. This time their order, they say as a graduate you cannot be considered.
So that
It is very plain and simple. The court's direction is that as a graduate you have to be allowed to participate, you have to be considered. They say no, in view of our advertisement, graduate will not be considered. There is no consideration, there is no fresh, there is nothing. It is the same one and the same point. Not a single inch has moved. All the judgments you have relied upon, there was much beyond it. Much beyond it.
Not a loss. Just
all the judgments.
Kamal Mukherjee also implementation second one.
That judgment we don't know.
So that's one of the relying upon. According to this repetition, just because the contempt argument that defends the contempt, this is not also their defense, your lawsuits. The contempt ought to have been. They say again before the
no, that's why we are again and again saying, as a court, we have to see whether we want to encourage such a situation or we don't want to encourage such a situation. Whether we have to see.
This is not encouragement. Someone
that when we pass an order and somebody passes an order as if he is sitting in appeal over the order, then we should pass the same direction. He will pass a second time an appeal order.
No, I don't.
Third time also we will do the same thing. No, because it will become a routine for him or whoever it is, flouting the orders or passing orders as if he's an appellate forum over the order of the tribunal. When he knows that the tribunal has the power and jurisdiction to enforce orders passed by it and get it complied and also to punish for contempt.
Normal, ideal situation is that. But here your loss is one way or other, the defense is taken, contempt court is reluctant to proceed further. You go and with the liberty disposed of, go and challenge it at fresh.
Where is that?
I'm saying the usual course.
So we should presume.
No, your loss, this is done. Your losses, judgment is also that.
See, those things are all different things. Those are cases where the authority is directed to consider. There is no direction of a consideration in a particular manner. Then if an authority considers, surely it will not be a contempt. It will have to be agitated by way of a fresh application. In your case, it is a unique fact. Such orders are not very much in abundance. There is a specific declaration contrary to the terms of advertisement relying on which they were excluding you. The tribunal said you can't do this. They are well within their right to be considered even as graduate. Now again that 6.0.
But kindly consider now the other way around. But your lordship is now saying this could have been said by the tribunal also.
Therefore, we are saying it.
Tribunal has not said that.
Therefore, we are saying it. You have challenged the tribunal's order.
That's I'm saying.
Correct.
They have this approach could have been taken by the tribunal.
Correct. So, if everything was hunky dory, you would not have been here.
I tell you, loss. Situation arises. Contempt is between the court and the contemptor. By way of a fresh original application,
contempt was never initiated.
Court could have done it.
We don't know.
Court could have done it.
We don't know.
Now, that's my prayer. Even your losses could have done it.
Sure, we should take up contempt of the tribunal directly.
Tribunal, why they do this?
Very. So, therefore, now we will open another avenue to come to the High Court.
Not avenue, your losses for me. This is
and contrary to L. Chandra Kumar, which says no, that court has to be the court of first instance.
But that's your loss. That's the L. Chandra. The first court of. I'm seeing how they court looking at it.
Cannot be. This court cannot take it up directly. It's not it is not a contempt of this court's order.
I am saying
if at all it is a contempt or violation, even if you are alleging that it is contrary, then it is not this court's order.
As I have no any order passed contrary to court's order is a nullity. That's settled law. So, my lord, the order impugned is a nullity. Then what remains to be given, my lord? They have to consider me without bereft of graduate, non-graduate. Rest of the
All-
thing they have to follow. That's Malad the prayer.
That's all.
That's all. Malad, your losses, kindly see this judgment only. Malad, 2007 7 SCC.
We have already gone through it. You have already placed.
Not the end. I have placed your losses paragraph 2 to 6. The factual portion of it.
No, we have seen everything.
Oh, then your losses okay. Malad, paragraph
Paragraph
30,
28, 29, 30. That is why we said
That's-
that. Yes.
that's your losses. Malad, here also the court said, Malad, consequential relief.
Correct. There the court did not pass any direction what all relief was to be granted. The authorities understood consequential to be consequential after his retirement because he never worked on the hand.
Is there the order in the
And there is a contempt filed. The court finds that contempt is not made out.
court says contempt dismissed.
Correct. So not made out means dismissed. If contempt is made out, it will be dismissed.
I tell you losses. Contempt court says contempt made out. And ultimately, up to the Supreme Court, everybody held that order was not complied. What sort of justice, Malad?
No. The Supreme Court said that consequential would include the areas even prior to his retirement.
Obviously, the order was passed when he was in service. Everybody knows it, your losses. Somebody gives
If an order of the
something,
court,
dismissed.
if an order of the court is not specific, then will it constitute a contempt? You tell us what is the law.
Malad, if according to me, what I have read in
No, not you and me. The simple query is if there is no specific direction,
there is no contempt.
then
But here was a specific direction.
that we don't.
That's
Now
that's
that issue that is over.
Here you also, that's why I am citing these judges. The consequential
Yeah, it is
benefit
over.
above respond were 2 and 4. From the date of
We'll
that,
see. We have understood what you are asking.
this is just the Porihat note. Porihat's judgment, your losses, as your losses seniority was not complied with your losses. Paragraph 6, your losses.
Yes, there was only a direction to prepare the seniority list. Not that he should be placed at such and such seniority.
Here, seniority was not drawn in accordance with the rules. That's so. Contempt jurisdiction, sometimes court says no, you go before the regular bench questioning the rejection order. When there is a rejection order, the court often says you have to. Unless. These are my answers.
Yes.
My lord, I'm led by Mr. Senior Advocate Ravindra Bagh, my lord. He was online, my lord, but due to some technical problem, he was
Been
there, my
logged
lord.
He has been logged off.
May I call him up, my lord?
Ask him. My
lord, I have instruction that he has asked me to pray before your lordship to kindly make it tomorrow or next week so that he can go through all these judgments if he wants to differentiate all these judgments which are.
The arguments
Grateful, my lord.
Only one thing your losses was found in the order. That has expired. You have not come up since the matter that the list that your losses there.
When it lapsed?
That 19th May.
What was the interim order date?
Keep one seat vacant. Wicket problem.
16/5. 16/5.
16th May. Yeah, of course, 16/5. This was extended, initial order extended from time to time, and last extension expired on 16th May.
Oh. Where is the extension? Earlier extension. That 27/9/24. Last extension is on 7/3/25. Or April. But that will continue. There is a submission advance. Item number 10.
Hello, item number 10 is Sushantopal is appearing on behalf of the appellants. There is a change with legal at matter. I am paying for 2 weeks time for appellant. There is change with. I am paying for 2 weeks time for appropriate instruction from the client.
No, then why you have accepted? Then you should address us. What instruction? Before accepting, you have to take instruction, or after instruction? You don't.
High Court Legal Aid Authority. Huh? Sushanta Pal is the senior advocate in this matter.
Instruction you will take if you have been appointed by legal aid, then you should be ready.
He has instructed me that the client and instruction required from the client.
When you were appointed as counsel in this case?
I could legal aid.
When?
1 month ago. Try to contact the client, but we are appearing on behalf of the petitioner, my lord. This change brief, my lord. We have been engaged by the legal aid service.
1 month back.
But no conference has been held, my lord.
Why you are not taking steps when the matter is running on the list?
I don't know. My learned junior has informed me only last week, my lord, that matter was mentioned by him.
As prayed.
Appearance দিয়েছে?
Item number 11.
My lord, your lordship,
Reply already filed.
And the time may be extended.
There was a substitution.
Yes, ma'am. Allowed, ma'am. Similar and identical issue, my lord, your lordship has allowed on 1/8 of this month in favor of the petitioners.
What is the issue?
Hiralal Ghosh.
What is the issue?
Counting of first service.
Huh?
Counting of first service. Yes, ma'am.
1.5 years.
Maybe, my lord.
The judgment has been relied on by Malandran is that they were appointed in a particular scale of pay, but contractual of pay.
Oh, they were getting all other benefits.
All other benefits.
As if they were a regular employee.
Regular employee. But in this case, only the TDS pay worker.
Oh.
73 days. So in the year 1973, he was appointed, my lord. Similar and identical issue and continuous service from, my lord, that is a certificate, my lord, from 1975 to 78, 1979 to 1997, continuous service certificate is given by the authority concerned. And
under EMP 100?
No.
Yes.
Under EMP 100?
They were appointed on actual January 2009.
No, they are claiming benefit under EMP 100.
Yeah, yes, my lord, and the learned tribunal, my lord, passed order to absorb them, my lord, in the service on 26/9/2001.
Relying on which notification?
My lord, the government has, my lord, filed appeal dismissed and traveled to the Supreme Court. Supreme Court also dismissed the appeal of the government. Let affidavit in opposition be filed, my lord.
You only started argument. You were seeking adjournment. You started argument.
No, sorry, my lord. I am extremely sorry, my lord.
Yes. Time for the time granted earlier for filing opposition.
It is not uploaded as yet, my lord. Your lordship, kindly, my lord.
Call the next.
এটা একটু হিরালাল ঘোষটা 1 তারিখ অর্ডার দিয়েছে, ওটা একটু আপলোড করে দিন, ওটা একটু সার্ভারে দিয়ে দিন। Item number 12. 172.
Yes, you have said that his financial status was also considered. You have got the records. Just see. 3-member committee, whether it has examined his financial status.
It would be better ecologically grant me to file this all the documents via net.
Have you gone through or have you not gone through?
No, I have seen this record because according to my learned friend, because he died in 2014, whether the 2013 circular could be made applicable or on the date of consideration, what are the rules prevailing, that will be concerned. 2024 5 SCC he has relied that on the date of consideration that would be applicable, but there is another judgment in 2021 that on the date of death that circular will be applicable. There are two conflicting decisions by the Supreme Court.
No, but your specific stand was that apart from the fact that it is a belated request or it is for a time when he was a minor,
Minor.
the issue is you said that no, his financial status was also considered. So therefore, we asked you to produce the record to show us whether his financial status was considered by the 3-man committee or not.
Defense committee report is not here.
Not there. That is what is required. Therefore, we are asking you. Get it, get it. You get it.
Affidavit file করেছে ভগবান জানে।
Item 13, 14.
13 minutes. I am for the rest.
I am for the petitioner, my lord. I praying for time. I am for the petitioner, my lord, praying for time. Senior unable to come. Sudden illness. Due to sudden illness.
Sudden illness.
Pending before the tribunal.
There is any interim order.
There is no question. Is a regularization occurs in a sanctioned post. 16th September 2011. Since he was not engaged in a sanctioned post. Since he was not engaged in a sanctioned post, that's why.
The matter is still pending.
In 15.
In this matter,
But in this matter, I appear for the respondent number 226.
this
Damodar
matter, your
school.
lordship,
Now the thing is this, the thing is this, we are suffering an interim order before this honorable court. We won the battle before the tribunal. Now the petitioner came up before this honorable court. Ultimately, he has got an order of stay in respect of his transfer. Now the school is suffering because the interim order is continuing for a long time.
Since
I believe 2020,
lordship, in this matter,
2024, April.
27/8/24.
Yes. So, by strength of the interim order, he is enjoying the relief and we are suffering. And this is a case of transfer. His whole case was this, that the order of transfer was punitive in nature, penal in nature. That should not have been passed. And in fact, against that order of transfer, he made a representation, and that representation was taken into consideration by the concerned authority, and certain relief was given to him. The place of transfer was changed. Even then, he was aggrieved because he is not interested to leave Calcutta.
lordship, Mr. Vikas, Senior Advocate Vikas Ranjan Bhattacharya is leading me in this matter. He was supposed to join online, but I think due to some network disturbance, he is unable to join, your lordship.
On last 2-3 occasions, on the ground of our senior friend, Mr. Vikas Bhattacharya, the matter was adjourned.
Last adjournment was on your ground.
Yes, your lordship.
Prior to that, 3 adjournments on your by the respondents.
That was possibly not.
My lord, in this matter, I am appearing on behalf of Union of India, my lord.
Last
Lordship,
adjournment
kindly
was
keep
also
it
on
in-
your ground.
In any case, the matter is ready for hearing.
All right. So don't say they are taking repeated adjournment. Therefore, we are saying
Any day, your lordship.
any day you tell us.
Next Monday, my lord, kindly give it priority. Next Monday.
Monday week. Monday week.
25. Monday week means 25th.
Week we are very much.
Monday week is 18th.
Grateful, my lord.
Week 11. 11.
25th. I'm extremely grateful, Kumar.
Take down an order.
$16.
16, Your Lordship, I appear on behalf of the state, Your Lordship. There was direction of affidavits. Opposition has been filed, but reply has not been filed till date. Rather, has not been served upon.
Item number 16, Lordship, praying for not today only.
Reply file करो बोलो चलो. इधर बोलो कोर्ट की reply है.
Lordship, for item number 16, praying for not today only, Lordship.
You filed a reply.
No, Lordship. I have been instructed over telephone that he has not come to the court, Lordship. So kindly keep this matter on tomorrow, Lordship. He will be here.
You have received instruction. That's all right. We are asking whether reply is to be filed, whether it is ready.
Lordship,
What is the status?
I have been instructed that reply has been filed, but it has not been affirmed. That's why, Lordship,
Then,
I have been instructed to sort for an adjournment.
then what? For what it should be listed tomorrow? Not 28. 27. 28th will be hearing. 27. Wait will be hearing.
17.
17, 18 and 19 are similar. Lord, I am for the petitioner in item 17, 18 and 19, my lord.
I am appearing on behalf of the BSNL.
Lord, I am filing my reply, my lord. My lord, only thing before I proceed with the matter, my lord, before the tribunal, my lord, our case was in fact supported by the BSNL here also. The person who are objecting, that is the union, they are not filing their opposition. Because BSNL have wrote to the authorities union that their pay scale should be revised. But the union are not accepting and they are not filing their opposition also.
They have filed a reply in the tribunal.
This Union of India is the answering respondent, my lord. Because they are objecting to this.
No, did they file a reply
No,
before the tribunal? Before the tribunal?
No, my lord. My lord, this is my reply. In item 17, this is my reply.
No, let us see whether whose objection it is. Let us see. If your instruction is that they are the answering respondent, then let them.
Kindly look into the OA application in the last two annexures. One annexure, previously an OA application is filed, my lord, is disposed of giving direction upon the BSNL as also the Union of India to pass a reason and speaking order. Subsequently, BSNL pass a speaking order, reason and speaking order. Sometimes they are allowing the in favor of the petitioner, my lord. The Union of India totally rejected the same and they pass another reason and speaking order. Both reason and speaking order, they have second round of battle. The petitioners has challenged the reason and speaking order passed by the Union of India, my lord.
Where is that? Which page?
Uh,
176, if your lordship kindly come. 176. Presentation, madam.
This appears to be representation.
My lord, kindly come to page 189. My lord, my case is, my lord, I was appointed. There was no revised scale. I was appointed in a scale which is an intermediate scale of pay.
No, this is by BSNL. This is not
Yes,
by.
this is by BSNL.
So why you are saying that Union of India?
Yes, no, this reason that it is BSNL supporting us.
Actually, BSNL can beat the post and say to the Union of India Minister upon the same. But subsequently, Minister of Education rejected the competition of this. That's the problem. That's what the problem is from.
No, this says that it is pending consideration before the Government of India. Where is the rejection? Where is the rejection?
141. 141. 141.
That cannot be. That cannot be. That is prior to this 189. 189 says it is pending. How can a disposal precede that pendency? One 189 is of 10/8/18. 141 is of 2016. It's 2 years prior thereto. Where is the order of 28/3/2017? Yes. No, that is of 2016. 28/3/17.
Wait allow to original wait. 160.
Of of last
Wait,
of item 19.
second wait আমাদের কত?
Second row number 3.
Page 160.
Last item 19. Item 19 is
English number কতবার প্রেয়ারটা দেখি আইটেম নাম্বার 17 প্রেয়ার নেক্সট যখন করেছি ডেফিনেটলি কিছু ইন্ডেক্সে দেখো ইন্ডেক্সটা দেখো
ওটাতে আছে অ্যানেক্সে দেওয়া আছে অ্যানেক্সে ফটো
Yes. In 2007, when the petitioners were appointed, this association and the petitions they have filed, they were appointed in a pre-revised scale. There being a pre-revised scale, it was termed as intermediate scale. Subsequently, when it was new pay scale was drawn, my lord, it was the opinion of the BSNL that this intermediate scale should be petitioner should be placed in the immediate next higher pay scale.
Show us where does it say next higher pay scale. Show us.
Is that which BSNL is the video to no. My lord, page 189, my lord, may I please?
Yes. 189.
My lord, may I place it as a whole? Undersigned is directed to, I am skipping paragraph 1, my lord. The learned counsel therefore take liberty for the tribunal, my lord, not required now. In third paragraph, in the above cited cases, Secretary Swanso and Swanso have been made respondents numbers mentioned here. In the questions addressed to the BSNL, this speaking order is being issued on behalf of government. Now, my the representation dated Swanso is preferred by the applicants, which have been summarized by CMO BSNL and a candidature.
No, you said that intermediate abolished and direction to place in the next higher.
Higher.
So where is that?
This one. Next paragraph, my lord. Third line, fourth line.
Which?
Swanso granted ideal
no,
pay
don't.
scale of rupees Swanso corresponding to CDS pay scale of such and such with effect from 1/12/2000 in respect of JTOs and equivalent grade pay of BSNL. Under second FFC Department of Public Enterprise by Swanso dated Ato notified the revised ideal pay scale from EO to E1 with effect from 1/11/2007 in respect of below board level executives of Ato. However, revised pay scale corresponding to E1A pay scale credential was not notified by DP. This is my specific case.
There, where is the policy decision that upon abolition of intermediate, it has to be placed in the next higher scale? Because your opening line is that.
My lord, it is at page 191, last paragraph, may I?
Yes.
Because of the fact that the presidential order dated Swanso issued by DOT is not in accordance with the BSNL's proposal, BSNL has requested.
We are not asking you about any proposal. You said the policy, your submission is that there is a policy in abolition of intermediate and placing in the next higher scale.
This is, my lord, they are actually, this is being done, then I will be in the higher pay scale. If this.
So there is no policy. Now we have come to a different position. You said there is a policy, there is no policy, there may be a proposal.
BSNL has in this order, my lord, BSNL has stated their request to the DOT to place it.
So there is no policy, then that submission is not. Anyway, we'll see.